Yes.
Your Lordship, may I be permitted to mention item 20. This is a specially assigned matter before Your Lordship for extension of interim order. The interim order is expiring tomorrow. Lordship, this is the connected matter with these Mandarmuni hotel demolition cases that Your Lordship was hearing. Lordship, item 20.
Item number
20. Lordship, specially assigned.
20.
Yes, Your Lordship.
When was it assigned?
Lordship, this has been assigned just yesterday.
Recently.
Yesterday, Your Lordship. Now it has come up with the other matters because Your Lordship were hearing two
Why
connected
is
matters.
mentioning?
Lordship, for extension of interim
Let
order.
the matter be called on at least. Wait.
Your Lordship.
May I humbly mention 226 of the daily list?
Yes.
Lordship,
Why
my
are you
bank account has been
Frozen.
frozen. I'm mentioning for upgradation in the list.
Sorry,
So-
please. Do not mention.
My bank account has been frozen by
There
the
are many matters. It cannot be upgraded. Yes.
Tender matter. I am
Uh-huh.
lowest bidder, my lord. My application has been rejected on the in violation of provision 17E of the Panchayat Budget Act rules, my lord.
Yes.
This is very simple matter, my lord. My application has been rejected. I am the lowest bidder, my lord.
There may be reasons. It is not necessarily all L1 bidders have to
They
be
are going
accepted.
to issue work order, my
There's
lord.
nothing doing. You file it in the department, it will be seen.
Then, my lord, kindly take it urgent motion, my lord, as urgent motion.
You file it in the department, let us see.
I am
I have
filing.
your lordship's kind leave, my lord, to mention the matter, my lord, for inclusion, my lord, in the.
No, today it is not being
Lordship, may I
allowed.
be permitted to mention a matter? It was item number 1594 of the monthly list of March of your ladyship's list, your lordship. This matter was the petitioner here underwent the eye cataract surgery for a free eye camp conducted by a state general and super specialty hospital.
What you want, please tell me.
For upgradation, your lordship.
Not today.
Kindly, your lordship.
Not today.
Lordship, for upgradation.
No, no upgradations
I'm
and
mentioning
inclusions.
upon notice, Lordship. This is the case of a department. The petitioner was the bid of the petitioner.
You
was-
first put your band straight.
Sorry, Lordship.
This is not the way how you should appear before the court. Get ready, dress up properly, then come. Yes.
Leadership, if I may just seek your leadership's kind leave to mention a matter. This is for inclusion. However, if I may just indicate my urgency, on the 26th of March, I have received a notice from the railway authorities wherein allocation of rakes to my business has been stopped. Your leadership, immediately there was a holiday on on the supervening weekend of the last month. On the first, I have filed. Your leadership, my business has come to a standstill because the rakes are not being allocated. I'll tell your leadership why. Because they have charged an arbitrary wharfage and demurrage charges which are not applicable to me at all. Your leadership, my entire business is
But
at
then
the standstill.
there must be other businesses also. This is not the only
The
business
sole
that
business. I'm an LLP, small LLP in the district of Purbo Medipur. Your leadership, kindly. Just anytime next week.
Where is the matter?
Your leadership, it's not. We've just filed it on first. I'm told that the date for which the matter is supposed to come up is on.
You get the
next
number.
Monday.
You get the number. Let
I
it
have
appear
the
in
number.
the list.
I have the number, your leadership.
Very well. Give it.
Anytime next week.
Next week, Wednesday, it will appear as urgent motion. Serve notice in the meantime.
Grateful to you.
The kind leave, well, item number 434, if your lordship's list, my lord, that this matter, well, on last occasion,
I am not upgrading matters.
well, not
please do
updated, my
mention.
lordship will kindly see, this is the notice I have received, my lord,
No.
was pleased to fix on 7th of April.
Yes.
Well, the problem is that, well, if you, not 7th of April, I'm extremely sorry, well, 7th of March, well, I have mentioned this matter, well, your lordship will kindly see the notice once.
Tell
my lord.
me what
A
is
proceeding
there.
is going to be initiated against us, my lord. Already I have challenged the initiation of the proceeding. Now, my lord, your lordship was pleased to call for the records, and also an affidavit has been also filed from the respondent authorities. But on seeing the urgency, your lordship was pleased to fix under the heading hearing that the one, my lord, it's item number 434 of your lordship's list. But your lordship, my lord, was not, my lord, could not be taken up with the business of the court, my lord. If your lordship, my lord, fix it, but any time, my lord, the proceeding is, my lord, going to be initiated, my lord. We have only prayed for some time.
Whatever proceeding, the final result will always be
Finally, another
outcome of
urgency is that,
the.
well, another urgency is that, well, I have prayed, well, for getting back my, well, stock in trade, well, it's worth, well, 15 kilos of gold, well, which has been seized by the enforcement director without any following any rules and regulations, well. And
Sir, please
well,
wait.
well, if
It
your
cannot be
lordship,
done. See, if you waste time
I'll
in
take your
mentioning,
lordship,
it
well,
cannot
half
be
an hour
done.
of your
Sorry.
last moment, well.
That contempt matter today appearing as the notice to Mr. Siddiqui, but today appearing as and last officer they have submitted the report saying that they can calculate the initial date of our appointment. But that matter is presented as 488.
Come
lord.
after the
My lord, may I be
application time, then we can.
My lord, may I have a urgent leave to file a matter, my lord, on urgent basis, my lord. My lord, I am a 70 years old person, my lord. I have been I have been in the garb of a credit card fraud and a savings bank account fraud, my lord. And the RBI rule says that within 3 days, if I report to the bank and the concerned police station and my local police station, my lord, I have a zero fault liability, my lord. On that score, my lord, I approached the ombudsman. Ombudsman, without hearing me, my lord, ombudsman rejected my complaint on false basis, my lord. And now the bank is deducting money from my savings bank account, my lord. I have no liability on that score, my lord. This is the urgency. The bank has already deducted 66,000 from my savings bank account when I have a liability of 1,90,000 alleged liability, my lord. My lord, this matter may be taken up, my lord.
It cannot be taken up.
My lord, the urgency is, my lord, the bank is
Sorry, nothing doing. Yes.
Saying so,
Upgradation, please do not mention.
my lord,
I have refused everybody.
Monday,
Yes, yes. Command list, please mention.
that's the feedback.
Lordship,
Yes,
may I be-
call the list.
My lord, may I have my lord's leave? Kindly, there is an urgency. I would not have troubled your lordship. Item number 375, my lord. It is a matter challenging the technical bid of the tender, my lord. The financial bid is getting opened, my lord. Yesterday the meetings have been held. Today it will be opened, my lord. Kindly, my lord, it can be taken up.
It cannot be taken up.
Item number 375.
It cannot be done.
my lord.
Yes,
The whole
item 1.
picture will become infructuous, my lord.
May I please your lordship? May I please your lordship? Your lordship, this is a matter. Yes, your lordship, I appeal for the petition. Your lordship, this is a matter where a very sorry state of situation has happened, your lordship, in spite of your lordship repeated orders upon the bank. Your lordship, remember, this is a matter where I
Where
have
is the
made
bank?
I don't know, but they were to file a report. If your lordship sees the last order, last chance was given on 13th March. 13th March 2025, your lordship sees, the bank was directed to return my LICI policies and they were to file a report positively by 28th March. And nothing has been done, no report circulated. They are holding on to my title deed and the LICI policies.
But unfortunately, there's been a demise in the family of the main council, Maridi. Unfortunately, that has happened very recently, Maridi. I'm just praying for a little time, Maridi, so that the main council may appear and appraise the honorable
Lordship,
court.
every time they are appearing and taking adjournment, your lordship, I am opposing to this. Kindly see from 11th February.
Of the council, that's the only reason why I'm requesting, Maridi.
No, my learned friend appeared on the first occasion. My learned friend appeared and wait for time to file a report. 11th February, your lordship records the name of my learned friend. Kindly see, they have been taking time and again. They are not releasing my documents. They are liquidating my LICI policies in spite of payment of the entire dues of the bank. But this is very unfortunate.
Tell me one thing. Did you take back the LIC policies?
Yes, your lordship. I went to the bank on 19th of March 2020 pursuant to your lordship's order. I have a letter. They have refused. They are saying that without instruction of the higher authorities, I will not return you the LICI policies. I have given a letter categorically recording this fact. They have received it on 21st of March. No reply, no controverting. They have not denied the fact. On 19th of March, I went to the bank pursuant to your lordship's order. They said that without instruction, I will not do it. Continuously, they have been flouting your lordship's order time and again. In spite of repeated opportunities being given.
Maridi, I'm only seeking for a little time, Maridi. I'll just have to seek instructions in this regard. Unfortunately, the council who's been appearing in the last few days.
They might seek instruction, but your lordship will, I beseech your lordship to pass drastic orders.
There's been a bereavement in the family. That's the only reason why I'm requesting, Maridi. Because if Maridi could just grant me a week's time or a 10 days time, I'll seek instructions. The council themselves will appear and appraise the honorable court.
Your lordship, I'm opposing to this. From the month of January, February, they have been taking time in this matter. I'm opposing to this. Even your lordship's order has not been complied with. The LICI policies have not been returned. They say that in spite of High Court's order, I need instructions from a superior authority. I have put it on record by way of a letter. They have received it on 22nd of March. Till date, no complaints of your lordship's order. And they are holding on to my title deeds. In spite of payment of the interest. Yes. Mr. Roja, kindly place the letter of 20th March on record before your lordship to show the compliance.
The bank was directed to file an affidavit.
Your lordship will kindly have a look at it.
With an advance copy circulated by 28th March 2025. Stop. The same has not been done till date. Stop. Paragraph. Learned advocate representing the bank seeks accommodation. Stop. Paragraph. It appears that time was granted on repeated occasions to the bank to disclose their stand. Stop. The direction for returning the 4 LIC policies to the petitioner has also not been complied with. Stop paragraph. The branch manager of the Standard Chartered Bank, being the respondent number 3, is directed to remain virtually present
My only request is if my lady would grant me time, there's
on
only
the on 22nd April 2025, when the matter will appear in the list. Stop. Report of the bank. No, the direction passed by the court on 13th March 2025 shall be complied with prior to the adjourned date.
Your Lordship, one thing, if your Lordship kindly considers one prayer, your Lordship kindly considers prayer I, page 25. The LIC, my contention is that they are liquidating the LIC policies after the maturity in 2019 in spite of payment of the entire dues. I am saying that let them not liquidate my LIC policies because I paid the entire money, because those are lying with the bank.
The LIC policies of the petitioner which are lying with the bank shall not be liquidated until further order.
I am grateful. Extremely grateful.
Item 2, my lord, I am appearing on behalf of the petitioner. This petitioner is the flat owner and permanent resident of a particular
respondent number 4.
housing
I'm
complex.
for the state, Mal.
4, the president of the.
My lord, this petitioner is aggrieved by several illegalities committed by the office bearers, particularly, my lord, if your lordship kindly comes to last order.
The report of the competent authority, you've gone through it?
Yes, I have gone through, and my lord, report is completely illegal, my lord, and it cannot be done. If your lordship kindly comes to page 102 of my petition,
show
your
me the
lordship will
report.
find
102.
Huh?
Yes.
Report is before your lordships, but my lord, before that, why I have come before your lordships, kindly comes to page 102.
Yes.
My lord, kindly sees the board managers, the number of board managers shall not be less than 3 or more than 24, but when there are the upper ceiling is more, in our apartment there are 555 flat owners. In our case, it will be not more than 48. My lord, kindly comes to paragraph 3 of page 102, and whereas clause 2 of bylaw 7 of the West Bengal Apartment Ownership Bylaws 2022 provides that the number of managers of a board shall be equal to 1/3 of the number of the apartment owners of the property concerned, but in no case it shall be less than 3 or more than 48. Therefore, the associations which have more than 72 members but not more than 144 members shall have 1/3 of the number of members as managers, since the number of managers will not be more than 48 in those cases. And whereas all the associations having more than 144 members shall have 48 managers, being the upper ceiling. In our apartment, there are 555 members, so it must be 48.
How many elections were held?
And my lord, election was held. There are 2 elections were held. In this election, before this election, my lord, there were 24 members. And the notification which came out, they are said only to fill up the vacancies. That means 24. Our case is, it cannot be only 24. Whenever you will go for election, you have to elect 48 members. My lord, kindly comes to impugned order, that is page 128. Page 128.
See, 24 was there, now 24 will be elected, so it will come to 48. Where is the difficulty?
Yes, my lord, in piecemeal manner, it cannot be done. My lord,
when was the last election held?
In February, my lord.
This year?
This year, February, my lord. And
why only?
Not only 11 nominations were received. That is the reason we could not fill up the remaining 24 vacancies.
My lord, sorry.
Yes, yes.
My lord, kindly comes to page 128, the impugned order. This authority has received a complaint dated 6th of March 2024 from Mr. Sommojit Bishwas of flat number so and so, with an allegation against the Board of Managers of Moonbeam Apartment Owners Association for not maintaining the strength of Board of Managers according to the bylaws. A reply has been sought from the President of the Moonbeam Apartment Owners Association regarding the same, and the President has given reply on 27th of March 2024. Thereafter, this authority had convened a hearing of both the parties on 4th of December 2024. In the hearing, both the parties were heard at length and the relevant documents were examined. I'm skipping, and found that the strength of the Board of Managers is not as per bylaws. The association's Board of Managers' current strength is 24, but as per clause 7(2) of the West Bengal Apartment Ownership Bylaws 2022, it shall be 48, as the number of apartment owners is more than 146 in this case. In view of the above observations and in exercise of the power conferred upon this authority by Section 16(b)(1) of the West Bengal Apartment Ownership Act 1972, the President of Moonbeam Apartment Owners Association is hereby directed to take appropriate steps to fill up the vacancy. Here I am pausing and here I am raising objection. They have admitted that by any means that cannot be less than 48, but they are saying they are allowed only to fill up the vacancy of the Board of Managers of the association following procedures as laid down in Section 8. Now, my lord, kindly comes to page 104. 104 is the 104 is the 12th annual general meeting, also considered special general meeting for declaring election. Here, my lord, kindly comes to next page, page 105. 105 column, paragraph 4. As per the West Bengal Apartment Ownership Act 1972, as amended by the West Bengal Apartment Ownership Act 2019, Chapter 3, heading Constitution of a Board of Managers and its Functions, Clause 7(2), the number of managers of a board shall be equal to 1/3 of the number of apartment owners to the property concerned, but in no case it shall be less than 3 or more than 48. However, it has been decided in this 12th annual general meeting dated 4th of February 2024 that the maximum number of board managers are going to be elected in the coming election are remain unchanged. That is 24 numbers only. This is illegal. They had the knowledge about the notification, but still.
But their alibi is that they received only 11 valid nominations. What can be done?
My lord, that is regarding the subsequent election. But my lord, in the previous election, only 24 was there. Now they are coming with this alibi. Initially, they did not have this point, my lord. In the report even, they had not stated this, that only 11 persons nominated. My lord, in the report also.
My lord, we have mentioned it,
No,
my
in
lord.
the report, paragraph number 8, it is there.
My lord.
My lord, this was the second election to fill up the vacancy only.
No, previous there were only 11. That is the reason only 25, 24 could be selected.
My lord, in that election, only 24 persons, my lord, placed nomination and they were elected. Only
11
24.
placed nominations received by the.
This is regarding 17th of February 2025.
My lord, may I join the issue, my lord?
Fill up the vacancies only. These cannot be. This is absolutely illegal. My lord, apart from this, we have some other grounds also. One is very important. After filing of this writ application, the president, secretary, and the other members, they are constantly threatening me and pressurizing me to withdraw this writ application. We have lodged several complaints before the police station also, my lord. This should be deprecated. My lord, I have come before the apex court of the state. I have the right, whatever be the result of this case. But how I am
Just wait, Mr. Farmania, you have the report with you.
My lord, I have the report, my lord.
Please come to paragraph number 7.
My lord, the competent authority heard the issue from both the parties in the hearing held on 4th of December 2024. Since the 24 board of managers have already been selected by mistake, the competent authority considered the matter and directed the president of the association to fill up and rest vacancies following the procedure laid down in clause 8 of the said bylaw.
Right. So if the authorities of the opinion that the previous election in December 24 was by mistake, then why will it not be rectified?
My lord, if there will be no person, no manager, my lord, the association cannot function, my lord. And my lord,
That
when
is
there
the
was
reason the
20,
election is required to be held
my lord,
and 48 in one go, not in piecemeal manner.
Your Lordship.
my lord, if your lordship will see the para 9 of my instruction, my lord,
Yes, I have
as
seen
per
it.
section, my lord,
Your para 9 says that it has to be direction can be given. The competent authority may give it to such direction as that authority considers fit. Right.
my lord. If there will be no manager, my lord, how the association will function, my lord? We have taken initiative, my lord.
There are already 12.
24.
11 for the new election, for the rest remaining 24, my lord.
24 is already there, functional.
My lord, my lord, my
Rest
lord.
24 is to be filled up.
My lord, for that, my lord, only 11 nomination has been filed, my lord. My lord, as per the direction of your ladyship, my lord, we acted upon it, my lord. We asked them to come and we came to learn that only 11 nomination has been filed, my lord.
That means the second election cannot be held also.
My lord, that is why we are leaving it to your ladyship. As your ladyship will direct, we will act upon it, my lord.
Then why are people not filing their nominations? They are not interested.
560 flat on earth.
Persons. They have
11
given the wrong
nomination,
notice. The notice should come for election of 48 persons at a time, at a go. They cannot do the election in a piecemeal manner. Now they are coming for 11. If 11 persons, they have filed their nomination, then the election will not be conducted.
Mr. Farmania, have you followed? See, 24 in the beginning, then 11, and then it will go on. 1, 2, 3, it
Not
cannot be
11,
done.
11 has not been elected, my lord. 11 has not been elected. We have passed the order, my lord, with our report, my lord. There is an order, my lord.
Yes.
Kindly peruse the order, my lord.
অর্ডারটা কোথায় না কোথায় রিপোর্ট
Where is the order?
Direction given, we have complied with the
order
direction given by your ladyship.
কোনো order আছে না এটা না
it is hearing notice order কোথায়
Your Lordship,
What does the order say?
Your Lordship, the order was submitted on the last occasion.
Let me
It
see
is
once.
না অর্ডারটা তো আমরা পেলাম অর্ডার দিয়েছেন
Order তো আপনাদেরকে পাঠিয়েছে।
আমরা শুধু রিপোর্টটাই তো দিয়েছি
না না অর্ডার তো আপনাদেরকে দিয়েছে কম্পিটেন্ট
It
অথরিটি
is-
পাঠিয়েছে আপনাদেরকে
25th February 2025 একটা order হবে দেখুন তো ওখানে
My lord, my lord.
Wait 1 minute, maybe it is here. Let me see. Yes, it's here. এখানে আছে
My lord.
25th of February.
অর্ডার আপনাদেরকে কম্পিটেন্ট অথরিটি পাঠিয়েছে
না ওটাকে মেলে পাঠিয়েছেন
What is the tenure of this?
My lord, 3 years, my lord.
3 years, right?
2024 to 2027.
If you go on with this piecemeal election, all along, the tenure of the board will be different. 24 for one, 11 for other, then again 24, this problem will be there.
Now, my lord, we are leaving it to a ladyship,
All
my
if
lord.
the election is held for all the members in one go, then the tenure will also remain the same. Otherwise, the tenure of the members, the managers will change. Isn't it?
My lord, as your lordship will have not. Kindly give a direction, my lord. We will comply with it, my lord. We were just trying to fill up the
Vacancies, but in
My
that
lord.
case, always the vacancies will remain.
I understood, my lord.
Years, the first 24 members, their tenure will be over. Again, vacancy, and then again filling up. So this way, it
My lord.
cannot be done. What is your submission?
If I may point out, the grievances of the petitioner lie elsewhere. He was going to construct a parking
which was then removed upon protest.
We will not go into that because he has not raised this issue.
But he is leveling allegations against the president and the board members. So if I may just point out with pictures that he had constructed a parking which was then removed.
Complaint has been lodged against him. Suddenly,
There
he
is a
cannot
complaint to
come
police.
in
But
my
since
case.
allegations
No,
are
no, it's
to
all right.
be filed,
This
if I may
is,
point
since
out
this is
that
not his
whatever-
case, we will not look
if
into
a fresh
it.
election is ordered, we will convene with this.
Right, because that will solve all issues.
Okay.
Please come. Heard submission made on behalf of all the parties and have perused the report prepared by the competent authority under the West Bengal Apartment Ownership Act 1972 on 24th March 2025. Stop. The order of the Special Secretary and the competent authority under the West Bengal Apartment Ownership Act 1972 dated 25th February 2025 has also been perused. Stop. It appears therefrom that there is a requirement of 48 managers in the subject complex. Stop. Only 24 managers have been elected in December, and there is December 24, and there is vacancy for the balance 24. Stop. The Special Secretary and the competent authority was of the opinion that the election may be conducted for filling up the vacancy of the balance 24 managers of the board. Stop. Such opinion of the competent authority does not appear to be proper in view of the fact that if the managers are elected in piecemeal manner, then the tenure of the board can never be fixed properly. Stop. The managers elected earlier will have a different tenure, and the managers elected later on will certainly have a different tenure. By this way, the board cannot function properly for a particular tenure. Stop. Paragraph. To put at rest the issue of election and the issue of piecemeal election of the managers, it appears that the best method is to conduct fresh election for all the vacancies, that is 48 at one go. Stop. The notice of election shall be published for filling up all the 48 vacancies. Stop. The competent authority is directed to take steps for conducting the election strictly in accordance with law. Stop. The election shall positively be concluded within a period of 3 months from date. Stop. Till the new board is constituted, the 24 elected members shall function and take care of the shall function in accordance with the provisions of the West Bengal Apartment Ownership Act.
Well, these 11 persons will not.
No, nothing. 11 persons, they have not yet. Has the election been conducted?
Election conducted, my lord, but in
No, my lord. No, my lord. Election, the second election
has
for
not
24,
been
remaining 24 has not been conducted.
not been
election
conducted.
If
My
you
lord.
kindly comes to the last order of 26.
Where fresh nomination will be called.
Your lordship directed that the fate of the election will be
abide by the result of the writ petition.
By this case.
The election which was allegedly conducted. What is the date? February 17th. No,
Your
date
passed
is
the order on 26 February.
February did the election take place?
My lord, last election টা কবে হলো? Last election টা হলো বোধহয় 17th.
My lord, the closing date was 17th of February
Closing
2025.
date I can see 17th February. Acha. The the election process which allegedly started in the month of February 2024 stands abandoned.
Grateful, my
My
lord. Grateful, my lord.
It petition disposed.
Grateful.
My lord, may I beseech one thing, my lord? If the petitioner wants anybody to be a election officer, my lord, it can be
Why?
done.
Why will you leave it on the petitioner?
But otherwise, he will
For
again
it
come, my
itself.
lord.
No, that is something else. You are the authority. Why will you? Today, petitioner will
My
keep
lord, we will do.
somebody's
We will
election
take
officer,
care of
then
it.
president will come.
from the petitioner.
Then somebody from the management will come. Why will you give this?
My lord, we will take care of it.
I appeal for the petitioner. Your lordship had, my lord, on the last occasion, passed an order directing, my lord, the director of micro, small and medium enterprises to be added as a partner. My lord, that has been done. We have also served the state, my lord, in terms of your lordship's order and prepared an affidavit of service. But may I file the affidavit of service?
Yes.
As a matter.
Director MSME is appearing.
But I represent, Lord, the respondent number 2, the resolution.
No, respondent number 2 is all right, but there was a direction upon the petitioner to add the director of micro, small and medium enterprise.
That has been done.
That has been done and copy served.
Yes, my lord.
Show me the service. See, addition has been made by name. Why it should be by name? It should have been by the designation.
Well, designation is there in one.
No, designation is not there in one. It is the directorate. Directorate and director of the directorate are different.
No,
Is anybody there from the state?
Well, we have, of course, my lord, added it by name. Well, that was, my lord, the understanding, but my lord, director of micro, small, medium enterprises, my lord.
Because their presence is required.
Well, this is, my lord, this is the name of the director, of course. But that your lordship will also find from, my lord, the petition. In all the communications that have been addressed.
No, it is all right. There must be a director. There's no difficulty. But at the time of implement, you do not add the person by name.
I agree.
This is the thing.
I agree.
And I see the notice was served in the office of the LR. But why is the AORs? Nobody is there from the state. I do not know. Can it be heard without in the absence of the
Tell your
state?
lordship, my lord, why, my lord, it has become very urgent. My lord, tomorrow, my lord, the matter has been, my lord, at my learned friend's instance. Once we move the writ petition, and your lordship was pleased to pass the order, my lord, they go running to the NCLT. They say that immediately hasten the process of approving the resolution plan. And my lord, the matter has been kept at their instance, my lord, tomorrow. Now, my lord, the Supreme Court has very clearly said now that, my lord, so far as these challenges are concerned, while the challenges to the MSME registration is pending, my lord, the matter should not be proceeded with.
Lord,
That is, my lord, what I shall be showing your lordship.
Lord, the lady is present, Lord, from the directorate. But she says that, Lord, they have applied to the government leader's office, Lord, for appointment of a council, and they have not. They have not, Lord, received any appointment, Lord, order.
Notice was served since it's the original side. AOR office has been served. Contact the AOR's office. So somebody must have been engaged. And the presence of the directorate is required. Please inquire. I'll adjourn the matter for the day. Come back tomorrow.
My lord, only difficulty is, my lord, tomorrow, my lord, my lord, the matter will be appearing. My lord, if your lordship kindly keeps it at 2 o'clock today, my lord, we shall come back upon service, if it's possible. I do not want to, my lord, naturally impose upon your lordship.
Two o'clock, it will not be possible today. At best, I can keep it tomorrow. And I have one more matter in the list. Review matter. I do not think it will take much time. So there is no scope for a passover either.
My lord, only
Tomorrow at the top, it will be there in the list.
tomorrow at the top. My lord.
Tomorrow, my lord. मामला तो open है tomorrow. My lord, we have.
My lord, may I only, my lord, pray this, my lord, in the presence of my learned friends, just for tomorrow, since the matter cannot be taken up in the absence of the parties today. My lord, both of us can request that the matter may be adjourned till the next date, whatever.
That is up to you all. I
There's a
cannot.
question of maintainability, my lord, of the petition itself.
Of course.
Relief that they have claimed is barred, my lord, under the IBC.
Yes.
I am not into the merits of the matter, so I cannot say anything. Tomorrow, nothing doing.
Lord,
Madam, please get in touch
tomorrow-
with the AOR so that somebody can be engaged and the matter can be taken up.
They have received it at 4:30 in the afternoon, she says.
Very well, get in touch tomorrow. I'll take it up.
My lord, tomorrow, my lord, kindly excuse, my lord, my present, my lord, someone else, my lord, will be there, my lord. Tomorrow I have some difficulty. So, my lord, I know, my lord, the urgency, because I would have shown, my lord, it's not maintainable on the face of it, but since, my lord, it's not being.
You can join
But-
virtually also. The court permits virtual hearings.
Right.
So you can be there virtually, no issues.
Grateful.
Please take back this service.
My application, your lordship.
What happened to the?
There was a direction for affidavit. They have not
Yes.
filed any affidavit.
What about the?
The auction, the reserve
auction.
price was not met by any of the bidders. So again,
Fresh
would be-
auction.
auction.
So the review application goes, isn't it?
Your lordship, the issue is pertaining to whether the applicability of which circular.
Right of first refusal.
I will seek a leave to file a supplementary affidavit. My department had sought from their superior authorities clarification, which is subject matter before this honorable court. So they have clarified with a reply. I'll file it by way of a supplementary affidavit. It could appear on Monday. I'll hand over the
Supposing so far the mental bit of the petition is concerned.
Review.
The application, my lord. Lord, if your lordship, before proceeding further, if I may rely on a judgment, my lord, kindly.
No, tell me what is there after
scope of the
disposal.
review, my lord. The
Yes.
scope of the review, what they're trying to,
Extremely limited.
extremely limited first.
Yes.
My lord, secondly, what they're trying to carve out a distinction between a policy and the scheme. Now, they are saying is the scheme is an independent standing all apart from whatever is there in the policy. My lord, my understanding of the law, with deepest of respect, my lord, a scheme cannot stand alone and has to be in the perimetria with the policy itself. So if the policy has provided a particular.
The court will not go into all these issues. This is review, extremely limited scope.
So far, and the last point, what they have asserted, that there is a fraud which has been played on my part because of the subject which was mentioned on the letter on 19th of December 2022. I've carried both the letters, my lord. The only difference in the subject part, one it's saying starting innovative idea, the other one is unsolicited proposal. So, my lord, I have taken instruction from my client. If need be, I'll come up with an affidavit on this. But what has happened initially, this letter.
Your client is still interested with this project.
My client is very well interested. Even they participated, they have put in a bid of 17 lakhs. But however, internally, I have came to know that the reserve price is much more higher. In this e-auction process, the reserve price has not been declared by Metro Railway. Now, on that.
GEM portal, your lordship.
And I have duly participated. I have put in a bid of 17 lakhs. I have already invested some of rupees 22 CR, my lord, as indicated in the writ petition. Now, my client is always ready and willing to carry with the project. My TVs are installed in the Metro Railways, 88 number of television sets, 700, more than 700 lying in my warehouse. Lord, there is no impediment if this project is being carried out through me, because time and again, this e-auction process.
You meet up the price.
Well, I do not know, because the reserve price has not been disclosed by Metro Railway.
No, it is there. It must be there in the GEM portal or somewhere.
It's through GEM portal automatic. Everybody gets to bid it high.
All right, all right.
My lord, on last occasion, what has happened, there are two bidders. One of the bidders put in 5,000 rupees, the maximum price for each and every rake of the Metro Railway. And my client all over given a quotation of 17 lakhs. However, all the
Those are
bid got
relevant,
rejected
Your Lordship, unnecessary
Well,
quotes our
because they have come up with a plea that on my instance, this auction is getting delayed because of my right to
No, right now it does not matter because it's open auction. Everybody is participating.
and this is
You
the
are also participating.
I have also but this is the second
Right.
auction. This is the second time no one has come forward, and the auction is further possibly put on 16th of April. This will be the third time. Now, instead of putting it in the e-auction another time, my client is ready and willing to. They have
So
already.
that is their policy. Whether they'll put it up in the GEM portal or wherever, it is up to them.
My lord,
Now, when they will see that they are not getting anybody, then they can come to you. That is something else. That is for the future. So I'll adjourn it for the time being. Please come. Learned advocate representing the review applicant submits that the auction, which was floated by the Metro Railway, is yet to be finalized. Stop paragraph. Leave has been sought to file supplementary affidavit. Stop. Relist the matter on 28th of April.
Your Lordship, earlier date may be given.
Why? Your next auction is on 16th of April.
Your Lordship, it is not limited to this auction. The scheme is applicable across India.
Let it be
It
applicable.
will be affecting everybody else because in the other states also we have metro rails under.
Why will it affect?
It cannot.
I
be, my lord.
cannot. I simply cannot
Railway
understand.
Kolkata, my lord.
You are trying to make out a different case altogether. You go and publish your advertisement, somebody will apply and you can get it done. What has it got to do with the petitioner?
He has been given right to participate. Made good the best bid. If he's the second bidder, he will be given chance to meet that amount.
You are the tender issuing authority. You want the money. Whether it is X, Y, or Z, you need the money. Right? So you go on open bidding. If somebody bids high, then petitioner has to bid higher. It is as easy as this.
No, as per your Lordship's order, he gets a choice. Whoever is bidding higher will become the second bidder. He will have to bid that amount. And
how does it matter to you? X bids rupees 10. He bids 5. He has to match up to 10. So you will get 10 in any case.
Right goes away, my lord.
Your Lordship, the second thing is that with regard to this order, as the circular has been placed before your Lordship, and we had terminated him within 1 year. After 1 year, he will be taking this point in the arbitration as well, that it was an illegal termination.
Look,
Because
that is an independent right which I
termination is a different thing.
I have not
Lordship,
come.
but the part of the circular has been implemented by your Lordship.
Nowhere, my lord.
Your Lordship
Request
has
of respect,
given
nowhere.
effect to the part of the circular which is not applicable to Metro Rail, by which the tenure was also not 1 year, 5 years.
I cannot remember. See,
Your Lordship, I'll place it on. Kindly give an earlier date.
21st.
Much okay.
Who is for the petitioner? Who are you representing? Union of India?
No, madam. This
Then?
time for a change, I am for the private
Respondent?
for a change, madam.
Well, I am for the petitioner, madam. Sorry.
Central Bank?
I am for the central bank, my lord.
Yes.
My lord, it was, my lord, listed at my instance, my lord, because I am facing a contempt in, my lord, execution of the orders challenge before your lordship, my lord. Before, my lord, I put the...
My learned friend makes a submission. There is a defect which needs to be removed. He has filed this writ petition against a dead person. Respondent number 4 is dead and gone in 2020. Now, Lordship, they had substituted that defendant in the trial court, that is DRAT, that is at page 167. If Lordships kindly come to page 167 of my Lord's brief.
Yes.
My Lord will kindly see Partho Mondol is the respondent number 2.
Yes.
And the substitution is on the next page, 168. Mrs. Maluti Mondol, Srimati Sweetie Mondol, Horshita Mondol, and Master Trijon. And the person is dead and gone in 2020, and they are aware. They have filed this in 2020. My Lord, keep to that. Now, my Lord, and they had substituted these defendants before the tribunal. My Lord, we kindly see this order. Only to delay the entire process. This has been done by them. Now, my Lord, if a dead this order has been obtained against a dead person, and my predicament, my precarious condition, and I'm an lady.
Who are you representing?
I am respondent number 5, the auction purchaser. I am an aged lady of 72 years now. I tried to get this particular house in 2014 by purchasing. I paid the entire amount. It was a surface sale. Now, my Lord, I was the auction purchaser 2014. The certificate was given to me.
Sale certificate.
Sale certificate. Now they had taken symbolic possession of that particular property. They could not take physical possession.
Who was the borrower? Partho Mondol?
Yes. Now Partho is dead and gone. They have not even substituted him properly before my Lord.
Yes.
Now this is the delaying tactics, my Lord. And what I had also challenged that order. Order was passed by the DM for police help for taking possession way back in 2015. That was set aside by a 2018 order. Now that was challenged in DRAT. Now that was again disposed of in 2018, and now they have challenged 2023. Now they have challenged that particular order before this honorable court. The order.
So you have not been given possession.
No, my Lord, that order which is under challenge, why I am affected, my Lord, because that order said that that amount should be refunded back to me.
I got it. Yes.
My Lord, so far the defect is concerned, my Lord, I concede, my Lord, it was a mistake on our part. That should have been, my Lord, taken care of and should have been added the parties. But so far the merit is concerned, my Lord, because since the aggrieved party or main consenting party is, my Lord, the auction purchaser, may I place my case, my Lord?
No, my Lord, not only that, my Lord, because Lordship will kindly appreciate. If the order is passed and Partho is not...
Today, till you cure the defects and you bring on record the heirs of the borrower,
and they need to
you
be
cannot
served.
proceed.
This is not 227,
my Lord, that can be done, my Lord, because since a mistake, admittedly it is a mistake.
No, it has to be done.
Yes,
It's
my Lord,
not a
that
matter
is
of
to
can be done. It has to be done. Then
but
it cannot...
the urgency is there. May I...
Urgency in their absence, in the absence of the borrower.
Okay, perhaps they are not agreed because the contempt has been put by them, my Lord.
Yes,
the
it will be
protection in the meantime that the contempt
on a defective writ petition.
Subject
cannot be done. Sorry, sir.
Subject to liberty to subject to liberty to make the corrections, my Lord.
Yes, I'll give that liberty to them. Correction, sir. Then I'll hear. Please come.
In the my Lord, may I, my Lord, I am not placing the merit of this case. I am placing that the DRT is already proceeding at their instance against the officers of the bank. But in contempt proceeding.
So
let no coercive action be taken in the meantime.
Why?
Because contempt proceeding, my Lord.
Yes.
They are not going to get
face the contempt. Where is the difficulty? You have accepted money. You have issued a sale certificate and you will not hand over possession.
But that is the going on, my Lord. Hand over possession, the order is there, my Lord. The DRT has set aside, my Lord, that order. So that is why I have come before your Lordship, because that the order setting aside the physical possession.
2014 sale certificate, we are in 2025.
Writ petition filed in 2023.
My Lord, the order impugned, my Lord.
I am not hearing you. Please
come. Order impugned, my Lord. Kindly see 2020, my Lord. Kindly see, my Lord, the order impugned.
The respondent number
23,
4.
my Lord, the order impugned. And only after passing this order, my Lord, I have come before your Lordship.
Expired on 17th of July 2020. Stop. The petitioners already applied before the Debts Recovery Appellate Tribunal for substitution of the deceased Partho Mondol. Stop. As the writ petition cannot proceed against a dead person, accordingly, the advocate on record of the petitioner is directed to amend the cause title of the writ petition by impleading the heirs of the deceased respondent as party respondents in the instant writ petition and serve a copy of the writ petition upon the added respondents. Stop. Release the matter on 21st of April.
Great.
Or the affidavit of service kept.
Yes, affidavit of service taken on record.
Grateful, my lord. My lords.
Deeply obliged, my lord.
But I appear for the respondent number 5.
I'm praying for the state, my lord.
Yes.
On the last occasion, there was a direction upon us. That will be recorded in paragraph 9.
You produce written instruction.
Written
disclosing
instructions
the
with regard to
steps
the
taken.
complaint at page 91 of the writ petition. Now, my lord, we have gone through. Now, my lord, we have gone through the complaint at page 91, my lord. But this is the written instructions. But if I may quickly go through, my lord, the our point addressed to me. I will the point. My lord, the entire complaint in the writ petition as well as page 91 is against a private body. It appears to us that respondent number 5 is a trade union, my lord. And my lord, the petitioner has allegations against the said trade union. Now, my lord, the trade union is not discharging any function which is bestowed upon it by the state. It is neither any directorate or any department of the state. It also, my lord, from the page 91, we could not discern that what activity or what project or what work of the petitioner is being hampered, because that is the allegation. So the allegation is that her work is being hampered due to imposition of mandate by the respondent number 5, not by the state. So, my lord, the only way they have tried their best to rope in the government to maintain the writ petition, my lord, is to refer to a review committee. Now, my lord, there was some impasse, my lord, in the film industry which appeared to us. My lord, the bureaucratic hierarchy suggested that a committee may be formed to look into the affairs. But, my lord, as far as the government records are concerned, there are neither any notification, nothing on record to suggest that any review committee was ever formed. It is also not appearing to us that any meeting of the review committee has ever taken place. Because, my lord, on our books, there is no review committee at all. So, my lord, if we take out that element of review committee, which they are banking on, my lord, there is no activity of the state or no restriction by the state upon them professing their profession, my lord. But that is the sum and substance of the written instructions. Now, my lord, to support my point, my lord, I could show, my lord, the Supreme Court decision. But, my lord, your lordship dealt with this point, my lord, in the book fair matter, my lord. If I may point out 4 paragraphs from that, my lord.
No use going into it. The moment it was placed, the court has noticed it.
My lord.
But the court is concerned with Article 21, 19, right to life, the right to business, trade. See that the persons can work
My lord,
freely.
as far as, my lord, state is concerned, my lord, state is duty bound to protect these rights, my lord. But, my lord, the petitioner, my lord, my learned senior will agree with me that the petitioner is not discharging any project of the government.
No, not a project of the
And
government.
no restriction upon her Article 21 or 19(1)(g) has been imposed by the state.
Yes.
Therefore, my lord, since, my lord, there is no restriction imposed upon the petitioner as far as state is concerned, my lord, perhaps, my lord, state will not be in a position to redress, my lord, the grievances that she has, which they seem to project, my lord, at page 91, my lord, though, my lord, your lordship may go through it, my lord, I can place it. There is not a single example that what is the hindrance that the petitioner is facing.
All right, then let me hear.
My lord.
What is the problem that you are facing? Why don't you intimate the
That
state
was
authority?
recorded in paragraph 9 itself in the writ petitions.
Paragraph
Not
9.
only the petitioners, other directors, my lord, who have also filed, my lord, 14 of them come, writ petition number, my lord, today's serial number 5 to 19.
I am in 8, similar matter.
Yes, what is the difficulty? Did you
Yes,
bring to the
my lord,
notice of the
I've
state?
recorded in my writ petition itself,
Wait.
paragraph 9.
Paragraph 9.
Those are the impositions, my lord. Virtually these federations, my lord, they are, my lord, discharging a parallel administrations. My lord, I'll rely on 3 judgments of the Honorable Supreme Court. It's the state obligations when there is infringement of 19(1)(g) and 21.
my lord, even if it has been done by a non-state actor, my lord, it should be the state's obligations, my lord, to preserve it. My
That
lord, if
is
your
the
lordship-
reason the court is interfering. Otherwise,
Yes,
on
yes.
the very
My lord,
first
that
day,
is
I
why,
could
my
have
lord,
thrown out the writ
if your
petition.
lordship wish me, my lord, I can produce, my lord, 3 judgments. I'll show these 3 judgments, and
Paragraph number 9 is your grievance.
9 is our grievance. Entire grievances are recorded in paragraph 9. The other instances after filing of the writ petitions, my lord, in February, in March, my lord, there are other directors, my lord, who faced trouble, my lord, those were given in the other writ petitions.
All right.
lord,
We are in item 2.
My lord, this paragraph is
9.
same as paragraph, my lord, it's same paragraph is there in the other writ petitions also. That will be paragraph 15 of, for example, item number 5.
Oh,
Now,
whatever.
my lord, if your lordship kindly takes a cursory look at this paragraph,
Yes, please.
he kindly sees the allegations.
And I'll show also the supported documents I have annexed. My lord, is the code of conduct issued.
My lord, ABCD kindly leaves out, kindly takes from C.
C.
E.
E.
The FCTWI has imposed a condition that whatever may be the condition. Kindly see who has imposed the condition. Then F, towards the middle, while the unit works under the HOD of the producer director's choice, the FCTWI imposes the compulsory presence of local crew member, so and so. Then G, the FCTWI has
It's
imposed.
true, but only for these reasons, the petitioners are not in a position to continue.
But it's a
with their
private
trade.
project in a private work where they get to choose the private technicians which they employ and which they pay.
But it is these
Without-
people who are not permitting them to work independently.
Well, I asked this question to myself, Malad, whether they have ever approached any of the statutory authorities, be the labor commissioner or whoever, Malad, under which these associations are registered.
No, my lord, under the Trade
They-
Unions Act,
my lord,
I have got the act.
he
but
has-
There's no nothing.
They have not approached anyone. They have directly approached the department, whereas these bodies are not having any direct nexus with the government, and at the cost of reputation, they are not discharging any function of the government, and the petitioners are not taking up any project of the government also, as far as these examples, whatever I found in the writ petitions are concerned. Madam. Nothing to link except for the review committee. Except for the
No,
review committee.
Suppose the review committee is not there. Is it not the duty of the state to ensure that its subjects can work freely? They can do their trade. You have to create
Well,
such an
that
atmosphere.
example is not there. The example is not there that the state has not done or done something to restrict them. Well, that is why I placed the pleadings. Generally, I would not take your lordship's time in placing the pleadings. The pleadings are not so. The pleadings are not that the state is restricted them or because of the state's inertness they are not being able to do.
Why do
Rather-
not you look into the problem and
Well,
find
we have
out
looked
a
into it.
solution?
Well, looked in. Well, your lordships may kindly also look into page 91. I can read every sentence of it, Malad. But the example, not a history is there.
How do you want the state to interfere and find
But
out
there are-
solution?
There are two things, Malad. One is state's obligations, Malad, to prevent the breach of these fundamental rights. And if your lordship permit me to submit, it's the court's duty also, Malad, to see that the no fundamental right is breached, even by a non-state actor. Malad, that is the law now laid down by the Honorable Supreme Court. Now, kindly take page 69. Malad, there was a strike for 3 months, Malad, for boycotting a particular director. Now, the Honorable Chief Minister, Malad, who is the minister in charge of the Ministry of Culture and Information, Malad, the
Thank you.
concerned ministry, Malad, she intervened and said that I am setting up a review committee and FCTWEI will no longer have overall control over the film industry. That was her commitment. Kindly first take the news article.
Yes.
No, don't go to the
Entire
news
source of
article.
knowledge is news articles.
Don't go to the news article.
Reported because there is no notification.
No, he
constituted a
admits that
committee.
there is no
No
notification.
notification.
Yes.
But it's the state obligations. Otherwise, I've given a data. Malad, in 2016, there was a 200 films Malad, went into production. Malad, in 2023-24, it came down to 136. In the last year, it came down to 25. In the supplementary affidavit, I have given these Malad figures. I have filed Malad on the first occasion.
The representations are all WhatsApp messages.
No, the email.
Two persons who are not even before your lordship.
Malad, if your lordship kindly permit me, Malad, to relying on certain judgments, Malad, probably that will answer, Malad, my learned friend concern.
Can the secretary come up to any help to y'all?
Yes, my lord. My lord, then either, my lord, I have got
Yes.
one prayer, my lord.
Yes.
Since the state government, despite committing, my lord, did not form any review committee.
Right.
So an independent committee may be set up by the court, my lord, with the help of any retired judge or somebody like that, but who will investigate and inquire into the matter that why this impasse is.
All right.
My lord, that is the only prayer. my lord, today.
Why doesn't the secretary of the department conduct an inquiry and find out?
As your lordship, my lord,
But
This
these
is
are
what
absolutely in
we-
the private civil domain.
May I just
Absolutely in the civil domain.
See whether they can work.
my lord, may I just
The atmosphere to work should be there.
My lord, there is first of all no example of any work, no example of any ongoing work, nothing.
If you say there is no work in the state, then it is very
No,
sad.
in the page 91, not in the state, in page 91, because your lordship's order is with regard to 91. Let my learned senior, my lord, disclose today before lordship what work is being disturbed.
Please come.
But these are civil problems that they are coming up with.
My lord, only one thing. My lord, the persons who is controlling these federations, my lord, he is of a very political repute. My lord, his brother is the honorable minister also. My lord, now it should not, I'm not taking any name, but that is why, my lord, these impasses are going on for a considerable period of time. Now, if the secretary is there, my lord, I don't know whether
You take names, make them parties and take names. Why will I be
I don't know whether he will act independently. That is why I have.
Very well. Let us see how he acts. Thereafter, we can take some, but we should go step by step.
I'll be asking for the same protections which your lordship granted on the last date in item number 2 for other writ petitions.
My lord, may I?
What is the protection?
Protection is that FCTW not to interfere with the
Lord, can I, Lord, have 2
Yes,
minutes,
sure.
your lordship's time? Lord,
All allegations are against you.
all allegations are against me. I am a bad association. Now, Lord, the issue is, apart from the fact that I am a private body, Lord, there is no allegation in the writ petition. These are all, Lord, allegations in abstract. That, Lord, she wanted to produce a film and, Lord, she did not get the technicians, or, Lord, the technicians refused to work with her. There is no allegation in the entire writ petition, Lord. I checked out. I did not find any allegation. That, Lord, she wanted to produce a film, or, Lord, one of her film is in the floor, and, Lord, the technicians are not working. Lord, there is an agreement with EMPA, the Eastern, Lord, India Motion Pictures Association. With this association, Lord, the producers, Lord, who produces this film, they have not agreed to a certain criteria. What would be the minimum wage to the technicians? How many technicians will be engaged? There are, Lord, agreed guidelines which are, Lord, followed between EMPA and, Lord, this respondent number 5. Now, Lord, there are directors who are not, Lord, parties to the EMPA. They are not, Lord, they are not members of EMPA. They can, Lord, independently come and they can hire. Now, Lord, in hiring the technicians, these are, Lord, job-to-job contracts. These are, Lord, independent contracts which are entered into. But, Lord, the guideline is the memorandum of understanding which we have with EMPA. So, Lord, this is how the respondent number 5 functions. It's not that, Lord, we function at our own ipsy-dixy.
Listen, there must have been some problem requiring the highest administrative authority to interfere.
Correct. That happened, Lord, 2 years back, 2-3 years back.
Last year, my lord, even this
That
year
happened.
also.
But, Lord,
Still going.
post that, there is a memorandum of understanding with EMPA. And, Lord, that is strictly followed. Lord, the trade union, Lord, has to, Lord, protect the interest of the workers, because these are job-to-job contracts. They are not, Lord, regularly employed. So, Lord, their wages, their, Lord, terms of service are to be, Lord, protected. This is the protection that the respondent number 5 gives.
In the garb of protection, if you are creating problem in working, then they
Lord,
will
let
not
them,
be able
let
to
them give
function.
one instance.
Yes, they will give
let
instance.
them give one instance.
They will give instance. Please come.
Lord,
Please come, please come.
petition is bereft of any instance.
Another prayer, my lord. I have filed an order 1 Rule 8 application.
Not
my lord.
served upon us.
My lord, it has been filed.
Lord,
But
they
it's
are,
not
they
appearing.
don't.
My lord, I asked for leave, my lord, to move this petition in the representative capacity.
No, but then you have 5 separate applications.
Others,
15
they
have
have-
come.
they have
Let
shown more to
them.
come.
Let us see
Lord,
what
if your
happens.
lordship is disposing of the writ petition.
No, I'm not disposing. I'm keeping it.
My lord, if your lordship may kindly look into that judgment, my lord, I was relying on.
Prior
My
to
lord.
that, the petitioner claims that the respondent number 5 is standing in the way of standing in the work of the petitioner in continuing with her. She's a producer.
Yes, he is a director, my lord.
Achha,
All
direct-
directors have come, my lord.
She is creating problem in her functioning in
the work of the petition and
no the stand of the stand কি বললাম প্রথমটা
the petitioner claims that there is
that the respondent number 5 is standing in the way of the petitioner
Only one paragraph.
in continuing her work in the film industry.
এটা হচ্ছে 99
Stop.
1
The grievances of the petitioner
আমার junior
are mentioned in paragraph number 9 of the writ petition.
CC
Stop.
741
The
27.
learned advocate representing the state respondent and the respondent number 5 raises a preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that the respondent number 5 is a private entity and writ petition against the same will not be maintainable. Stop. Paragraph. It has been contended that there is no specific instance made out in the writ petition describing as to how the petitioner has been prevented from performing her work
or
her
her right
trade.
has been affected. It is a tarot king.
Stop. Paragraph.
247.
Upon hearing the parties and on perusal of the documents annexed to the writ petition, it appears that
23-4.
an impasse in the film industry did take place,
Para 78.
for which the chief minister was required to intervene. Stop. Paragraph. As the petitioner raises certain issues with regard to her right to trade, comma,
Right to profession.
profession, trade jagah profession. Accordingly, the petitioner is granted leave to file a comprehensive representation before the Secretary, Department of Information and Cultural Affairs, being the respondent number 3 herein. Stop. Acha, ekhane time ta din. So within a week from date. Stop. In the event such a representation is filed, the same shall be considered by the Secretary in accordance with law after giving reasonable opportunity of hearing to all the necessary parties. Stop. A reasoned order shall be passed and communicated to the parties positively within a period of 4 weeks from the date of filing the representation. Stop. The fate of the representation to be filed by the petitioner shall be placed before this court on the adjourned date. Stop. Release the matter for further consideration on May 19th, 2025. Let copy of Can 1 2025 be served upon the respondents. Stop.
The supplementary affidavit has also not been served.
No, nothing has been served.
Where
upon
is
us,
the
sir.
supplementary?
I don't know, Lord, my learned friend was talking about.
You not serve?
Well, if they wish to rely on it, may it be served upon us so that we can come to it.
Has it been served?
On the state, my lord, I am giving it to my lord.
Yeah, আমরা পাইনি।
My lord, also the application for addition of
বলছে পাইনি, দাও না একটা copy।
Acha. The respondent number 5 is restrained from interfering with the functioning of the petitioner in performing her work, and none of her fundamental rights to life and livelihood and her right to carry on business, trade and profession shall be interfered with. What is this? What is this? Who? Did you hand up this? What is it?
That is the instructions that your lordship directed in terms of your last order, my lord, paragraph 9.
Instruction forwarded by the Additional Secretary and the ex officio Director of Films, Department of Information and Cultural Affairs, dated 2nd April 2025, be written with the records.
Lordship's direction is restricted to respondent number 5. The not to interfere, Lord.
Yes, respondent number 5 will not interfere.
Only thing is that, Lord, we have nothing to do with the hiring of, Lord, the hands. These are, Lord, I just make it clear that we have nothing to do with the hiring of hands. We have, Lord, set a standard and norms which is followed by the industry across the line.
Let the secretary go through it.
Yes,
if they
but
come
only
and
thing,
then
Lord, I am apprehensive that tomorrow, Lord, a contempt application that they wanted to hire at somebody at a lesser cost, and that person has refused. That will come on us.
let us see.
Kindly, Lord,
Let us see. No, as of now,
give us a protection on that, Lord. We don't, Lord, interfere in the hiring of hands.
But this order, Millard, would also take care of item number 8. Only, Millard, he is a gentleman, Millard, a petitioner is a gentleman, Millard, in item number 8. The pronouns will get changed.
No, the others are not gentlemen.
Wait.
She's a lady. She's a lady.
Wait, please wait. I'll go one by one.
5 to
One by one. 5 to 19.
all directors, you know,
We are not
Let
there.
it.
I'm not there. We are not there.
We have charged, my lord. We can-
Let it. No, it will called on one by one. It will become difficult. Please wait.
আমাদের চারটাতে নাম
নেই হবে না
আরো আছে
দেখছি
আমি সবকটাতে নেই বাকিরা আছে
call 3 please.
No. আমরা director of films ছিল, সবার সাথে 3 and 4 we are not there.
Whoever is there must be appearing.
yes ma'am 3টা অন্য মামলা
হ্যাঁ
এটা on
Yes.
আমার মামলাটা করবি না
পারফেক্ট হবে না
এই সাগরটা আপনি আমাকে পাঠিয়ে দেবে কারণ আছে
এটাই তো বলছি আমাদের
This is last
my application. Yesterday,
Are 2 petitioners still there or one has left by in the meantime?
no, my lord, 2 are still there, my lord.
My lord, subject to whether I do not know, my lord, whether my lord has signed the order or not. If it has not been signed, kindly hold for one minute.
Which order?
My lord, last order, my lord, yesterday, my lord has
Yesterday's order.
needs to pass. It has not been signed. Then, my lord, kindly hold for 1 minute. My lord, if your lordship kindly sees the petition, read petition first. এটা কোনটা রে এটাই তো বার কর read petition. Now, my lord, if your lordship kindly sees the petitioner number 1. Yesterday,
Petitioner number 1 is Samaresh Kumar.
under the law,
Samaresh Kumar.
Section 26 of the Code of Civil Procedure says, my lord, the plaint or my lord, the petition has to be supported by an affidavit. Now, my lord, if I consider for a moment that Samaresh Kumar Sarkar or whatever it may be, petitioner number 1, he has affirmed the affidavit independently. That means his status in the petition is independent. If that is so, my lord, he initiated the proceeding on the day 1 and enjoyed the interim order. Now, my lord has been pleased to observe that his name may be struck off, cannot be. Order 23 rule 1, my lord, it says, my lord, if he withdraw himself, wants to withdraw, there possibly must reason. Now, my lord, my learned friend has submitted, probably there is a pressure from the authority. For such reason, he doesn't want the. Now, my lord, I have the judgment to that effect, my lord, of this court, that it cannot be withdrawn. Now, my lord, this is our judgment.
He cannot withdraw from the writ petition.
No. My lord, that is the judgment order.
Because he is enjoying an interim order.
Exactly, my lord, I shall show.
But then the interim order will be vacated when he withdraws.
My lord, the issue remains, tomorrow is the last day to file the prosecution. And
Yes.
yesterday, my lord, he has enjoyed. Till yesterday, because now I have to prepare the prosecution case. I have to file it. Due to this, by the strength of this particular interim order, I am not in a position to prepare the same. Now, my lord, today we are on, my lord, 3rd. Why tomorrow is the last date under the statute? I am to do it.
So you must have prepared it in the meantime.
They are not petitioners anymore. Let them do whatever they want to do with them. I am
No,
not
that I
concerned.
understand, but then you must have prepared it in the meantime. Have you not prepared the prosecution? If you know
It's under
tomorrow
process. I cannot say that it is.
Yes.
It has not been. It is under process now.
Certainly.
My lord, this is the. My lord, I shall show the judgment. That is, my lord, WP A6315 of 2021. It has been passed by this honorable court.
Reported.
Huh?
Unreported.
Reported কিনা আমি এখনই বলতে পারছি না রিপোর্টেড অ্যাবসলিউটলি হ্যাঁ দিয়ে দিচ্ছি এটা একটু জোসেফকে
Before that, my lord, yesterday my learned friend took a point.
হ্যাঁ বলছি বলছি পর পর
Can be more than
আমি বলে দিয়েছি
one affidavit.
ওটা ক্লিয়ার করে দিয়েছি আমি জোসেফকে কালকে ক্লিয়ার করেছি
So that point in learned friend is dropping.
আমি বলিনি এখনো ওটা বলিনি বলছি this is the my lord, the judgment I am pressing that under order 23 rule 1 under the pressure if it is my lord
withdrawn,
it cannot be withdrawn.
Which portion? Which portion?
My lord, last well the petition my lord my lord, page 12 my lord, if you lord internal page the power under article 226 of the constitution India is not exercised within the limited scope of procedural and was but wide enough to take an account an illegality or irregularity of gross nature if committed by the authorities if so required. Hence, for the added the petitioner grants leave to amend the cause title so and so so and so. Ultimately, my lord, the writ petition he has prayed for the withdrawal that has not been allowed. And ultimately, my lord, I have got my lord the reference.
Where is that portion?
My lord, it is my lord, a huge case, my lord, where my lord.
If a copy is given to me, my lord,
Yes, certainly.
I'm reading.
No, but then the portion that you read out, there is nothing.
My lord, it starts
it must
from
be
the
some other paragraph.
No, my lord, it must be. My lord, may I submit, my lord?
Share it with him at least.
Yes, my lord. এটা তুমি নাও এটা তুমি নাও আমি আমার ইয়ে থেকে
open from the phone.
Yes, I have. First, my lord, my lord, let it be kept aside for the timing because let him read. Now, my lord, second part, my lord, if your lordship kindly sees the power of attorney. দাঁড়াও না. What does it say? By the strength of the power of attorney, my lord, the second affidavit that is at page 25.
এই পাওয়ার অফ অ্যাটর্নি ফটোকপি দেওয়ার কথা ছিল কালকে দিয়েছে ফটোকপি কোথায় রেখেছেন
Should I give one more copy? Finally,
দেখুন কোথায় আছে
একটা কপি আছে
yes what is there
How they got the power, my lord?
হ্যাঁ
How they got the power?
আমি কি করে পাবো আমি তো বললাম kindly see the power of attorney that was handed over to
Well, there are extra copies are here.
আমি কোথা থেকে পাবো
yes it is there I got it
দুটো কেন দিচ্ছি
I got it yes
আমি পাঠিয়েছি
হ্যাঁ
স্যার আপনি এইটা next my lord if you lord
yes power of attorney yes
my lord obviously my lord when the power of attorney has been executed it is unregistered and under the power of attorney act my lord to conduct the suit my lord if your lordship kindly sees whether this word is there conduct the suit Lord, obviously, my lord, to sign
yes to defend contest prosecute all or any suits appeal revisions legal proceedings litigation civil criminal anything under the sun
yes my lord proceed my lord now my lord 3 4 and 5 they are now withdrawing the case
yes
under the evidence act unless and until they produce an application before this court it cannot be withdrawn
power of attorney
yes power of attorney my lord he is just the authorized person but when the non-prosecution will be there that is the person who has to approach before this court and he has to file an application under order 23 rule 1
point of
withdrawal of suit there must be a reason to believe after enjoy my lord all along they have enjoyed the interim order
with petitioner number 1 there is no difficulty because there is no power of attorney for him for the
but he cannot withdraw at this stage
petitioner
when
number
he has wasted the court's time
that the court will see what is to be done
yes next
but
my
then
lord, the power of attorney
in respect of who is withdrawing 3 and
my lord 1 3 and 3 and 4
3 and 4
what 3 and 4 whether he is having the authority to say before this to submit under the evidence act section 32
because now the power of attorney has to come and say he cannot
he has to file an
3 and
application
4 doesn't have any independent say He has given power to the.
Recall the same. Thereafter, my lord, he has to
Anirban
approach.
Das.
Power of attorney is merely an agency.
Yes.
Is a law of agency.
Attorney Act.
Right.
So if an agency power has, does not mean that the principal loses his power. That is not the law.
Do you mean to say the principal also exercises his power and the agent also exercises the power?
Cannot be.
Can that be?
No. There can be power of attorney backed by consideration. In that
Yes.
case, principal loses power, the power of attorney has to act because it's
Yes.
backed by consideration. But in a simple power of attorney, mail of agency, it's something like I'm a manufacturer, I appoint an agent. I can sell myself, I can sell through agent. Both authorities are there.
It is not so. It is only because this 3 and 4 had given authority to XYZ.
If my friend's objection is that withdrawal should also by the power of attorney,
Yes.
I'll produce that next.
Yes, that has to be.
Now, my lord, this part is over now. Now, my lord, what is the merit in the case?
That he will submit.
Let him submit to that.
Yes,
effect.
merit he will submit.
Merit,
Merit.
let Lord, judgment. Lord, I will, my lord, it will be, my lord, helpful to him. Lord, I will be relying upon this particular judgment, my lord, passed on by the Supreme Court on, my lord, 28th March 2025, mere so cause. It cannot be challenged. My lord, this is the judgment.
No, this is a very
Yes,
settled law
2006 onwards.
that
2006
show
onwards.
cause cannot be challenged. Show cause is not any proceeding or anything of that sort. No penalty, nothing. It cannot be challenged.
Secondly, my lord, the technical part, I have annexed the gazette, the name of the person that is there. Yes, this is my.
May I proceed, ma'am?
paragraph.
So this point, Narayan is not pressing.
As of now, no.
As of now, তুমি বলে নাও তারপরে তুমি মেরিটে বলো না আমি
As of
judgment টা
now,
দিচ্ছি।
no.
আমি
This
কোন
is
জায়গাটা
not
পুরো
pressing.
দেখিয়ে দিচ্ছি।
No, so that I will reply to
আমি
this
আমারই করা।
also. So let me go to merits of the case, my lord. Let's get
Show cause stage.
show cause stage. I'm aware, my lord, that at show cause stage, the power of interference by of court is very limited.
Yes.
And restricted to certain conditions. What are those conditions, my lord? Let us first see those conditions and whether they fit into my case. Municipality judgment.
হ্যাঁ স্যার এখানে।
No. What are the different? This, well, we start with the facts of the case, but normally my learned friend is taking a
Try to be extremely precise. Please try to be.
I will. 1991. Copies are there. Well, this is a reported in 1991. Supreme Court cases Calcutta 463 is a single bench decision of our court. But when we summarize the whole issue very shortly, Lordship takes up straight away paragraph 17. On the basis of the decision cited, it appears that the court, in exercise of its jurisdiction under 226 of the Constitution, will interfere in a show cause notice in
the following circumstances.
circumstance. One, when the show cause notice ex facie or on the basis of admitted facts does not disclose the offense alleged to be committed. I'm taking that point. Two, when the show cause notice is otherwise without jurisdiction. I'm also taking that point. Three, when the show cause notice suffers from incurable infirmity. I'm also taking that point. Four, when the show cause notice is contrary to judicial decisions or decisions of the tribunal. Five, when there is no material justifying the issuance of the show cause notice. There are 5 grounds very crisply summarized. I couldn't find any other judgment so in summarizing so shortly, my lord. So Lordship asked me to be very short. So instead of citing 10 decisions, I'm citing 1 decision which summarize all the cases.
Yes.
So let me show how I fall into each of them. 1990. Lordship kindly first sees that.
Which page is the show cause?
Yes. Show cause is at page 26.
Issued by the
additional Director General, additional Director General, Mine Safety, additional charge, Eastern Zone, Sitarampur, Mr. Shyam Sundar Prasad. I'll show for the notification. His name is not there in the notification. Anyway, besides the issue, that's secondary point.
No, jurisdiction, you have raised an issue.
Jurisdiction, otherwise jurisdiction, I'm placing that. So, he said, please refer to the inquiry above accidents, undersigned, so many inquiry made. So, inquiry is over. Some person has completed the inquiry revealed this. Now, then say the inquiry further revealed that there are certain things. The inquiry further revealed that had. Let's mark the word had. The show cause notice not you have done this. This is the charge. The show cause notice says revealed that had this been done, the accident could have been, next page, Lordship sees, the accident could have been averted. It is a surmise and conjecture. Well, had I not passed law, I would not appeared here. So, had is not a, cannot form a charge. So, had these things happened, the accident could have been averted. And so, this is one part. And second thing, you as the agent, you have failed to provide training to the persons that will answer, implement system, prevent carrying on of mobile phones, so and so, operate short firers, implement safety. These all have been contrary to records because we have given them.
So why don't you go before them and say that these are contrary to records?
That is besides the issue. First thing is the person who issued whether he has the jurisdiction.
Yes, what is he is not the competent authority.
And logically sees that the about middle of the page, thus you are being held responsible for contravention of so and so. So he has made up his mind. So this is a preconceived and a closed mind. It shows closed mind. I'll show the affidavit also this point. Now, logically takes up the jurisdiction point, the Mines Act. It's there in the I filed earlier, man. The Mines Act. Mines Act, lordship, can you take up? First, lordship, can you take up? Mines Act would be separate, man. Mines Act file like this. I had a copy.
You have filed it possibly on the last day?
Yes, madam. I have referred to that. Might be marked also. Well, can I hand over extra copy?
1 minute, then the documents will again be multiplied.
Yes, that's true. One is already too heavy.
It's already heavy. Yeah, right. আর কোনো ফাইল আছে দেখুন আর কোনো ফাইল আছে
অন্য কোথাও ঢুকে গেছে দেখেছো মার্কস আছে দিকটা তো একসঙ্গে রাখুন এটা রিপ্লাই না তলায় কি আছে দেখুন একটু হ্যাঁ ইন্সপেক্টর এগুলো কি এতগুলো কি
Yes.
Yes. Dr. Kalni takes up first section 12. Lordship taken the Mines Act.
Mines Act. Yes, section 12.
Section 12.
Committees.
Committee. Here, my lord, there was an accident. There was an accident, a fatal accident. So, the central government shall, with effect from such day as the government may, by notification the official gazette specifying this behalf, constitutes for the purpose of this act a committee comprising of so and so person, not necessary. Now come to 13. 13. The committee constituted under subsection 1 of section 2 shall come to B. Inquiry into such accidents or other matters as may be referred to it by the central government from time to time and make reports thereon. Now, 14. The committee constitution 12 makes such powers of an inspector under this act as it thinks necessary or expedient to exercise for the purpose of discharging its function under this act. The committee constitution section 12 shall, for the purposes of discharging its function, have the same powers as are vested in a court on the Code of Civil Procedure when trying a suit, discovery inspection, enforcing action, compelling production, such other matter as may be prescribed. So, whenever if the accident, then it can be inquired by the committee appointed by the central government, and a committee is to be appointed by the central government. And that committee acts as exercise the powers of inspector and makes inquiries and adjudicates with the powers of a civil court. Now, Lordship, can we see the other section, section 24 of that book, possibly page 114, possibly section 24. Power of government to appoint court of inquiry in cases of accidents. Lordship, mark the word accidents. When any accident of the nature referred to in any of the clauses referred to 1 of section 23 occurs in or about a mine, the central government may, if it is of opinion that a formal inquiry into the causes of and circumstances attending the accident ought to be held, appoint a competent person to hold such inquiry, and may also appoint one or more persons possessing legal or special knowledge to act as assessor or assessors in holding the inquiry. So there is the law is complied with. The person knowledge of law is kept in the committee. So the person appointed to hold such inquiry shall have all the powers of civil court on the Code of Civil Procedure for the purpose of enforcing attendance, compelling any person exercise power of inspector and acts things fit as it or expend except for purpose of inquiry. So either whenever there is an accident, either the committee appointed by central government who can inquire, or the court of inquiry appointed by central government can inquire into the same. Now Lordship kindly sees that, look at their notification once. Then Lordship kindly takes up section 6.
5A হচ্ছে appointment, 5.1 হচ্ছে appointment, which they have enclosed.
6 is functions of the inspectors. The chief inspector may, with the approval of the central government and subject to such restrictions or conditions as he may think fit to impose, by order in writing, authorize an inspector named or any class of inspectors specified in the order to exercise such of the powers of chief inspector under this act, other than those relating to appeals as he may specify. The chief inspector may, by order in writing, prohibit or restrict the exercise by an inspector named or any class of inspectors specified in the order of any power conferred on inspectors under this act. Subject to the provisions contained in this section, the chief inspector shall declare the local area or areas within or the group or class of mines with respect to which inspector exercise respective powers, that is jurisdiction, territorial jurisdiction. The chief inspector can by notification can fix the zones or areas. Now powers. The chief inspector and any inspector may make such examination inquiry as he thinks fit in order to ascertain whether the provisions of this act or the regulations, rules or bylaws, any other orders made thereunder observed in the case of any mine. With such assistance, if any, as we things fit, enter inspect and examine any mine or part thereof at any time by day or night, provided that the power conferred by this clause shall not be exercised in a manner as unreasonably to impede or obstruct the working of any mine. Examining to make inquiry respecting the state condition of any mine, ventilation of the mine, sufficiency of the bylaws, exercise prescribed regulations. No person shall be compelled under this to answer any question, make any statement tending to incriminate himself. Section 21.
Why are
Article
you
21.
reading this section?
Well,
What has the inspectors got to do over here?
Nothing.
And why are you reading this?
No, because their case is as a inspector, X is appointed inspector, so he can inquire. That is their case in the opposition. I'll come to that.
No, section 24
Yes.
mentions about a competent person to hold such inquiry.
Okay.
Is it
No,
such that
person means when the central government appoints a competent person.
Yes, yes.
Court of inquiry.
Right. So the competent person can
only inquire.
Competent person can be the inspector. It is not necessary that
No,
the
madam, because
inspector
competent
cannot.
persons is defined in subsection 1.
What does it say? It cannot be an
Subsection
inspector.
of section 24.
Yes.
When any accident of the nature referred to in any of the clauses about a mine, the central government may, if it is the opinion, there is a formation of opinion necessary, that a formal inquiry into cases or circumstances attending the accident ought to be held. Appoint a competent person.
Yes.
That competent person is referred to in 3. So he acts as inspector. That is apart from his adjudication power.
Has the opposition enclosed any document appointing anybody?
No.
No.
No. I'll come to the notifications immediately, madam. No. And section 7, why I have shown that inspector or chief inspector has nothing to do with any accident.
Accident cases.
Whenever there is an accident, only the court of inquiry or the committee appointed by central government. Mine safety has nothing to do. Inspectors has nothing to do whenever there is an accident.
Show me the notification.
Loss. Loss. First law sees they are pleading paragraph affidavit opposition.
Opposition ta dekhi.
Opposition ta রিট পিটিশন আর এওটা এক জায়গায় রাখুন, হ্যাঁ এটা তো হবে না।
Which portion?
Page 8, paragraph 16.
Yes.
Because paragraph 21 is my para in the writ petition.
All right.
This is paragraph 21 because they replied to that.
Yes.
That is at page 11 of my writ petition.
Notification is R2.
R2. Well, the Hindi version starts from page 7. Oh, I'm sorry. May I please para 21 of the
Page
petition?
16, may I assist, my lord? Page 16.
Let me finish, my lord.
Page 16, my lord has got it.
Not yet.
Now, my lord, left hand side, my lord,
before that.
SO 2593. Now, my lord, serial number 1, 2, 3, my lord has got it. Serial number 3, Samsundar Prasad.
All right, let him place.
Yes.
The Lordship can first see paragraph 21 of my writ petition. Because
No, come to the notification. Come to the notification. Is this person notified?
23.
23, page 16, it has been mentioned in the AO.
Yes,
Page
very well,
16.
16.
Yes, yes, page
16.
16.
Page 16.
So, পরে আবার ratification.
R2 starts from page 14, at page 16. In exercise of powers conferred by subsection 1 of section 5 of the Mines Act, the central government hereby appoints the following officers inspector of mines, subordinate to the chief inspector of mines. So, Shamsundar Prasad is one of the inspectors only. He is not the court of inquiry, neither.
No, but then he has been appointed.
As an
Section
inspector.
5.
Only inspector.
Section 5.
Section 5. Lordship can see section 5?
Yes, section 5.
The central government, sorry, at page 1127.
Yes, yes.
The central government may, by notification of the official gazette, appoint such person as as possesses the prescribed qualification to the Chief Inspector of Mines for all the territories to which this act extends, and such persons as possess the prescribed qualifications to inspectors of mines subordinate to the Chief Inspector. So no person upon Chief Inspector or Inspector shall honorable become old on so and so, and district
Has
magistrate
any notification under section 24?
Not disclosed.
not disclosed, my lord, and neither alleged in the affidavit of
Accident occurs the subsection 1. 23 occurs. The central government may, for the formal inquiry attending the appoint a competent person. Section 24. Appoint a competent person. The central government appointing a competent person to hold inquiry.
neither has been alleged or disclosed. Section 24 or section 13. 12. Their case is section 5 simpliciter, and his powers is enumerated in section 7. Nothing more, nothing less. And which does not include inquiry into an accident. That's why it plays section 7. Because they say he's the inspector. So he can do everything. No, my lord. The act provides otherwise. Because an adjudicator has to have powers of a civil court. Give a show cause notice, receive reply, adjudicate, take evidence. He needs all those powers. Section 7 does not provide all those powers. Section 23. Lordship, looking about any portion, my lord, may I help?
Yes, next.
Well, the notification. So, the notification I was referring to, it merely under section 5 notification, not a section 24 or section 12 notification. And he's merely upon inspector, he can, at the highest, exercise powers under section 7. But he cannot exercise power under section 12 or section 24. Now, see, as per and their case is that show cause letters in question, their pleading, have been issued to the petitioners based on an inquiry well within the jurisdiction as per notification dated 17/4/23, that is page 16 I have shown. They say they are adjudicating on the section of that notification, and I have shown lordship that the notification section 5, and he can at the highest exercise jurisdiction on section 7, and there is no notification by central government under section 12 or section 20.
Yes, I got it.
So this gentleman, and lordship also sees at page 23 their notification
Saying that based on an
inquiry.
And
Right.
refers to
Their
17
other notification lordship sees at page 23.
Yes.
17th April 2023. This is the referred in paragraph 16. We'll kindly see. They say on basis of this notification, he can exercise jurisdiction. And what is this notification? I, Prabhat Kumar,
yes,
Chief Inspector of Mines, and also designated as Director General Mine Safety under the power conferred on me under section 3 of section 6 of the Mines Act 52, and supersedes all previous notifications issued on this behalf, hereby declare the area of jurisdiction of zones and regions in respect of which inspectors appointed under section 1 of section 5 shall exercise their respective powers as given in the appendix enclosed. So it says, give me territorial areas, and lordship turns of the page.
Yes, I followed it. Then
At page 24, Sitarampur region 3, this is one of the regions. That's all. So the allegation at page 8, para 16, that he is
what is the notification at
jurisdiction on the 17th April.
Yes, I have followed. What is the notification at page 28 of the opposition? Notification regarding appointment, promotion,
Very,
leave.
very interesting, my lord. Lordship, you see the English versions.
Yes.
English version starts at page 35.
Right.
Same notification.
Uh-huh.
In fact, 33.
33, yes.
From 33. There are transfer of judges. I don't know what this has to do with this case, my lord. First one.
So not it's not related.
Chief Justice Bhanumati Madras High Court.
Page 35, page 35, I can see.
35.
18th of December, Ministry of Labor, section 5(1).
Right hand side, bottom left.
Right hand side one.
Shamsundar Soni, not Shamsundar Prasad.
There are two names. The respondent number 2.
Who is the
Samsundar Soni.
Samsundar Soni is not given a so-called notice. And even if it is section 5 appointment.
Section 5 appointment. All right, then.
Not section 12. So Samsung, not his name is all not. Lord can look at page 35, 36. Shamsundar Prasad name is not there at all.
And 37
And 37, the name of Shamsundar Prasad is there. Lord can you see?
Yes, 37.
37. This Mantralaya ke
Shamsundar.
English ta daini.
ওটা যেহেতু ওখানকার নোটিফিকেশন
मंत्रालय के दिनांक February 8, 2022 कार्यालय आदेश नंबर स्वयं के अनुशालन में my lord I have been service in Bihar for long.
Page 37.
मैं निम्नलिखित अधिकारियों को स्थानांतरित
स्थानांतरित
करते हुए
1 minute, 1 minute.
निम्नलिखित अधिकारियों को स्थानांतरित करते हुए उनके सामने बताए गए स्थान पर तत्काल प्रभाव से पदस्थापित किया जाता है. They are transferred to this post. So Shamsundar Prasad, he is transferred.
Very well, very well. Then next, what is the next point? So it is without jurisdiction according to you.
Transfer orders, nothing here, neither there. So,
এটা 45 45
why do you কি আছে?
এই শ্যামসুন্দর সোনি আছে আবার
ঠিক আছে, page 45 my lord, and it says that कि कालज में also कार्य आवंटित किया जाता है. So there is posting. Number 1, Shamsundar Soni is posted to Sitaram Sector 3, Purbiya Eastern Zone, Sitarampur.
not Shamsundar Prasad.
So merely appointment as under section 5 and transfer orders.
Anything else?
Yes, madam.
Yes.
Now if you look at the affidavit now. Para 23. I'm sorry, AO para 12. I'm sorry, AO. AO para 12.
AO para 12.
On page 6.
Yes.
Now I am on the second limb. First, without jurisdiction. Next is the preconceived or closed mind.
Yes.
Now, with reference to paragraph 17, so inspection reports and statements are not at all required to be submitted to petitioners for submission of the expected reply. Lordship kindly looks at my, I'll come to that, sorry. Now, for issued to them for the contravention of provisions of Mines Act, rules, regulation, orders made thereunder. Observed, revealed during inquiry. So, inquiry over, and he has already made up his mind that there is a contravention of Mines Act. Then, logically,
No hearing, no.
I mean, or this hearing is going to be a post-decisional hearing. He has already made up his mind. K.I. Schaeffer's case. I need not cite those, multiply those cases. And Lordship looks at paragraph 30 then. I'm sorry, para 19. Repeatedly they say
yes.
The inspection report 19 about after the allegations, the inspection reports and statements of witness not required at all to submit an effective reply. Well, that I will decide to the so-called letters issued to the petitioners for the contraventions of provisions of Mines Act, rules and regulation orders made there. Siemens case, Siemens. On this matter, I will cite a judgment. Well, I'm citing 2006-12 Supreme Court cases, page 33.
Hey.
No, Siemens Land has been considered in this particular judgment we have seen.
Yes.
Lordship can we takes up paragraph 8.
Yes.
The question as to whether jurisdictional fact existed for issuance of the said notice the order passed the respondent was in question in the said writ petition. Now, although ordinarily a writ court may not exercise its discretion and jurisdiction in entertaining a writ petition, questioning a notice to show cause unless the same entail appears to be without jurisdiction, as has been held by this in some decisions, including so and so, but the question herein has to be considered from a different angle, namely, when a notice is issued with premeditation, a writ petition would be maintainable. In such an event, even if the court directs the statutory authority to hear the matter afresh, ordinarily such hearing would not yield any fruitful purpose. See K.I. Shepherd. It is evident in the instant case the respondent has clearly made up its mind. It expressly said so both in the counter affidavit as also in the purported show cause notice, as in my case. Now, what is the principle? The said principle followed by this court in V.C. Benares, the Vice Chancellor appears to have made up his mind to impose the punishment of dismissal on the responding hearing. A post-decision hearing given by the High Court was illusory in this case. It is common experience that once a decision has been taken, there is a tendency to uphold it and a representation may not really yield any fruitful purpose. Then, my lord, 11. A bare perusal of the order impugned before the High Court as also the statements made before us in the counter affidavit filed with respondents. We are satisfied that the statutory authority has already applied its mind and has formed an opinion as regards the liability or otherwise of the appellant. If in passing the order, the respondent already determined the liability of the respondent, and the only question remains for his consideration quantification thereof, the same does not remain in the realm of a show cause notice. It does not remain in the realm of show cause notice. The writ petition of our opinion was maintainable for the reasons aforesaid judgment can be sustained. Set aside, the appeal is allowed and the matter is given High Court for consideration after some merits. So. Because High Court has since retaken show cause, High Court has failed to intervene. Just as SB Sinha has pronounced in this manner, my lord. I don't want to multiply cases on each subject. So I have submitted he had no jurisdiction. And if he has no jurisdiction, writ court can interfere. My second case is it's a premeditated or closed mind, the affidavit. So cause both proves the same. On that, I rely on 2006 Siemens. Now, Lordship, we very often, my lord, we come across situations when respondent says, my lord, they are statutory authorities, they have ample powers. Well, that is not the law. The law is a natural person can do anything except which is forbidden by law. But a statutory authority can only do those things which are circumscribed by statute. Do I need a petition to cite? No. So I'm not citing on that one. So here, on the face of it, no notice under section 24 or section 12 by central government. All appointments are section 7, so they can.
Very well. These are more or less your submissions.
The third issue.
Again, third? Yes. What is it?
But the third issue is the show cause notice does not disclose any offense.
All right.
Page 26.
Despite that,
and my lord, my third issue is natural justice. In my reply at Lordship,
the inquiry report was not forwarded to you.
Inquiry report, statements obtained, and it is a specific case that Lordship kindly sees.
Second notice to the kid.
না দেখাচ্ছি ওগুলো দেবার দরকার নেই।
Not required to submit an affidavit.
Para 8, my lord.
Yes. Para 8 of?
Para 8 of opposition.
Opposition.
And with that, if you also kindly consider last day's order, my lord's order.
I have requested my lord not to sign.
No, not that. Before that.
First, the opposition, please show.
The opposition, page 4, paragraph
Page 4, paragraph 8.
About 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line. The
Yeah,
middle.
it starts from.
Answering respondents
Yes.
are not supposed to provide inquiry report and statements to notice for submission of their reply. This is statement. Apropos this, Lordship can seize my lord's order. On the last occasion. Lordship specifically directed that why they will not give document to state in their affidavit of opposition.
Very well, they will say, make submission.
And so, my lord, my third limb is
violation of natural justice. Yes. Next.
And Lordship said that the petitioner's request, I'm just placing for my lord's order. Request certain documents.
Paragraph number 3. I have seen that. Yes.
Pursuant to reply given.
And my lord, in our opposition, we specifically say, please give us these documents. So we file a preliminary reply. If you give us, we'll file a comprehensive reply. To that, at page 606, Lordship has seen on the last occasion, may I place once more?
606.
That should be volume 4.
Writ petition.
Writ petition, Lord.
Yes. What is there?
May I read out, my lord?
Yes.
This is to inform you that your request for further extension, who had asked for extension? I have never asked for any extension. Considered as ample time provided to you, nothing about giving of documents. So they have refused to give documents. And the next page, in case your reply is not received in this office within the above extended period, it shall be deemed that your above referred reply is final and you have no further explanation to offer. And actions as per law shall be taken against you without further reference. So they have expressly
refused to hand over documents.
Hand over documents that and they have adjudicating without giving you opportunity. So natural justice.
Anything else? Anything else?
And
yes,
fourth point is the allegations on the face do not disclose any offense. They are in the nature of I may show one or two, my lord, of their allegations. I can explain each one. I mean, show that each one is useless. Lord, you can take the at page 27 the show cause notice. আমাকে রুলসটা দেখি আমাকে রুলস ওই ট্রেনিং রুলস ট্রেনিং Number 6, lost vaccine. The person engaged in the mining, transport, handling, and usage of explosives been provided training in such jobs as required under Rule 13 of the so and so and so. And what does Rule 13 say? It's just an enabling clause. Rule 13, lost vacancies. The rules, mines vocational training rules, 1966. That separate bunch I have handed over. Rule 13 at page 1477.
Yes.
Training of person in handling of explosives. Every person other than a qualified short fire buster who is likely to be employed on a job involves handling before he is to employ additional course training under chapter 3 of the undergo a course of training in the handling. Where is the violation of this? I mean, this simply says you have to do this, give them training and all this. These are all enabling clauses. You have to do these things. These are not penal clauses. It is not that you have violated this. This is the penalty. Like in disciplinary proceeding, you say this is the misconduct and this is the penalty. These are all simply do's and don'ts. There's no allegation as such.
Yes.
Well, in my file is finished, my lord. If necessary, I will argue the other points, my lord.
First, jurisdiction.
Section 5.
Section 5.
Section 5.
Yes.
Chief Inspector and Inspectors. The central government may, by notification in the official gazette, appoint such a person possesses the prescribed qualification to the Chief Inspector of Mines for all the territories to which this act extends, and such persons as possess the prescribed qualification to be Inspector of Mines subordinate to the Chief Inspector. This is the provision 5.1, and I have shown the gazette. My learned friend has placed. There are two things. First, my lord, if your lordship sees what are the procedures in these particular issues, what is to be done by the inquiring officer? The inquiring officer is like, my lord, investigating officer under the Criminal Procedure Code. The document section 10 of the Mines Act provides that yes, I shall not disclose anything. Complete, I have the authority. I shall file the charge sheet before the CJM. CJM will consider whether this act has been done in a proper manner or not.
Wait, show me the first, not the documents, the jurisdiction.
Yes.
Whether section 5 jurisdiction and section 24 jurisdiction, competent authority is the same.
Exactly. Now, my lord, if your lordship kindly kinds, they have claimed that they are public servant. Note that.
No,
Public servant undertaking, we are not duty bound to issue that particular to obtain the consent. In a
Which
public
consent?
sector, but here there is a provision that they have indicated in their reply that
no, that has not been placed. Section 24 has been placed, which mention about the come to 24.
Yes.
The central government may,
May,
if it is of the opinion that a formal inquiry into the causes and circumstances attending the accident ought to be held, appoint a competent person to hold such inquiry.
Yes. My lord,
where is this?
Yes. Now, my lord, when an accident of the nature referred to in any of the clauses of subsection 1 of section 23. Now, my lord, kindly come to page section 23.
Yes, loss of life.
Where there occurs or about a mine an accident causing loss of life or serious bodily injury.
Here there has been loss of 8 lives.
Yes, not less than 8 lives. My lord, there are others also, because who are not enlisted workers. We know that. We know that. Now,
yes, then.
Yes, now, my lord, here the central government may, if requires. There is a word may.
So, your case is it has not been section 24. No, has any opinion been taken? If it is of the opinion, so an opinion, formation of opinion is also required. A formal inquiry into the causes is to be held. That is also to be done. Then appointment of a competent person to hold the inquiry. Where are those?
No, a minute. But these are confidential documents. Milord, if your lordship kindly allows me, I can.
No, is it there?
Yes,
Have
yes,
you
Lord, I have. I have not annexed because I shall disclose while filing the charge sheet that I have obtained. Information consent now. I have. If your lordship wants to see, Milord, I can. Milord, if your lordship can see, I have informed that this thing has happened, and thereafter we are.
Appointment of a committee.
1 minute. Intimation about. No, this is the intimation about the fatal accident.
Yes, Milord.
810,
This and thereafter, Milord.
Take this. I want to see whether under section 24 any steps have been taken or not. Anybody, any competent person to hold the inquiry. Inspector is somebody else. No. Inspector has got his own functions under the act. It is all right.
Yes, Milord.
Only for the purpose of an accident causing an inquiry by a competent person. Where is that document?
Yes, Milord. Now, Milord, if your lordship kindly sees the gazette.
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 See, if it is not there, I can set this aside, grant you leave to conduct it afresh. That can be done, no difficulty. But first of all, you have to satisfy the court that this section 24 has been complied with.
No, সেটা তো বলতে পারে। সেটা কোর্টকে বলতে পারে। No, Milord. Then, Milord, whatever.
Yes.
Because I cannot open.
Right.
Yes, Milord, that I shall not.
I know somebody appearing for the petitioner and somebody appearing for the respondent. There is a lot of difference. Please come. I know you will not do that. And the petitioners আচ্ছা তার আগে the petitioner numbers 1, 3 and 4.
Subject to lordship's kind sanction merely.
The petitioner numbers, had this been said on the first day, this would not have stayed in this court at least for so many days.
No knowledge. My lord, I would not have. My lord.
The petitioner numbers 2, ওই 1, 3, 4 মামলা করবে না. Petitioner numbers 2 and 5, who are proceeding with the writ petition, are aggrieved by the issuance of show cause notice by the Additional Director General holding additional charge of the mines on 31st of January 2025. Stop. The first point of attack is that the issuing authority does not have the jurisdiction to issue such notice. Stop. Paragraph. In the instant case, it appears that there has been an accident and more than 8 lives were lost, apart from others who received bodily physical injuries. Stop. The matter was inquired by the authority and the petitioner has been directed to show cause as to why steps will not be taken under the Mines Act, 1952. Paragraph. According to section 23 of the Mines Act, 23(1) within bracket A, whenever there occurs in or about a mine an accident causing loss of life or serious bodily injury, the owner, agent or manager of the mine shall give notice of the occurrence to such authority in such form and within such time as may be prescribed. Section 24 of the Act prescribes that whenever any accident of the nature referred to in section 1 within bracket 1 of the Act occurs in or about a mine, the central government may, if it is of opinion that a formal inquiry into the causes of and circumstances attending the accident ought to be held, appoint a competent person to hold such inquiry, and may also appoint one or more persons possessing legal or special knowledge to act as assessor or assessors in holding the inquiry, Stop. Paragraph. From the affidavit in opposition filed on behalf of the respondents, it appears that there is a gazette notification appointing an inspector in accordance with section 5 within bracket 1 of the Act. Stop. No document and/or averment has been annexed and/or averment made in the affidavit in opposition with regard to appointment of the competent person to hold the inquiry in accordance with section 24. Stop paragraph. In the absence of a competent person to hold inquiry, comma, the inquiry allegedly conducted by the authority and relying upon the inquiry report directing the petitioner to file show cause cannot stand in the eye of law. Stop. The petitioner has raised other issues also in the writ petition with regard to the preconceived mindset of the authority, comma, violation of the principle of natural justice, and the fact that no notice has been, no offense has been disclosed in the show cause notice. But as on the very first point, the court is convinced that the authority could not have issued a show cause notice to the petitioner, comma, the court is not commenting on the other issues raised by the petitioner. Stop paragraph. The court is of the opinion that the impugned notice dated 31st January 2025 directing the petitioner to reply to the show cause cannot be held to be valid in accordance with law. Stop. The same is accordingly set aside. Stop. The respondent, it will, however, be open for the respondent authority to take steps in the matter in accordance with law, if so advised. Writ petition disposed.
Lordship, not including a sentence on natural justice.
I have mentioned that you have raised this issue, but as I accept your first point, I do not go to the rest. This has been recorded.
Next time also they will not give document. Some it can Lodge can lay down the law.
No. Lay down the law. It is nearly 1 and item number 3 going on.
My lord, section 10 is very clear. I have not supplied any document, my lord. Section 10 is very clear.
I have not said anything about that also. So you act in accordance with law. Please wait. Janababu, এটা ওনাকে ফেরত দিন। ওনাকে ফেরত দিন। 1 minute. Take back these things because no use keeping all these things over here.
There may be appeals, so let them be on
Next
record.
time they will come. Again, you have to bring all these things. এই total জিনিসটা ফেরত যাবে। এটা ফাইল কভারটা খুলে নেবেন। এই অ্যাপগুলো ফেরত দিয়ে দেবেন।
Well, only one thing, proposed notice and consequential steps.
Did they take any consequential step? I will take that. I'll keep that into consideration. এইটা থাকবে আমাদের। এগুলো থাকবে না, দুটোই পিটিশনারকে ফেরত দিয়ে দিন, কোনোটাই রেকর্ড করা হয়নি। Yes, would you like to make any further? It's over. ওই act গুলো ফেরত যাবে. Please take back the acts. I'll return it. They'll check it up and they'll return. File coverটা খুলে নেবেন.
এসে গেছে।
শুধু একটা রুলস যেগুলো আছে সেইগুলো ফেরত দিয়ে দেবেন।
পরে এসে নিয়ে যাবো।
It will be returned.
He's busy. পরে এসে নিয়ে যাবো।
এই প্রদীপ লাগবে কি?
These are the two affidavit of service, Millard.
Yes.
My land
On behalf of the respondent number 227 and respondent number 10.
I am for respondent number 1, Millard.
Millard, Millard,
the only thing.
1 minute. Let me see the cost title first.
Kindly, that's the reason I give it to Lodge.
227. Director, Government Marketplace, 227, all gem, and 9. Not 10.
7 and 10, madam.
10. All right. And you are for 1. Only 1.
Only one.
Acha. And respondent number 8 and 9.
8 has.
Rashtriya Ispat Nigam Limited.
It has responded, I am told. Lordship will check.
8 has responded.
That is what I am told in the email. There's an email of the 8 on record, my lord. Are a copy ache tomar? Affidavit of
In the affidavit of service?
Yes. That's enclosed in the affidavit. Page 3 of the affidavit of service, my lord. It's there.
Towards the bottom.
Towards the bottom, page 3 of the affidavit of service. May I take it out for your lordship? Eight is Rashtriya Ispat Nigam Limited, Visakhapatnam Street.
I can see Jim.
Yes, Jim. And
No, but then,
8 is Rashtriya Ispat Nigam.
ah, where is that 8?
8.
8's response?
Yes. Ache, may I just see it myself?
Yes, yes. Then,
Page 9. Page 9.
In the other
The other affidavit of service, lordship. The other.
oh,
I should put myself, my lord, submit. আজকে status report টা কোথায়?
but you are aggrieved by Jim's action?
Yes,
All right.
by the James action.
Yes, say.
One.
What is it?
Yes. Well,
This honorable court doesn't have any jurisdiction.
Very well. You
Does
take
not
that.
have any jurisdiction.
Yes, very well. Kindly, Millard, kindly have a look at. Kindly have a look at, Millard. The order, Millard, passed by Jim at 107 of the writ petition. Millard, Jim is, Millard, government e-market portal. It's an interactive website which can be on a platform which can be accessed, Millard, from any place within jurisdiction. Offers can be made, offers accepted, payments can be made. That's Jim, Millard. So, Millard, now we say, Millard, the Millard dynamic effect can be felt. Or in our time, Millard, it's an interactive website. If your lordship, Millard, takes page 107 of your
Yes.
lordship's brief, this is, Millard, the order of Jim. Kindly look, Millard, how harsh it is. Millard, this is, Millard, this, Millard, is 27th of March 2025. Please note that in accordance with Jim, incident management policy as decided by the competent authority with regard to the incident number such and such, the transaction from your Jim account has been suspended for a period of 730 days. That's 2 years. Starting from 27th March 2025 and ending on 27th March 2027. This is due to non-payment of the transaction charges within the prescribed timelines of as per the Jim policy, order number such and such. During such time, your carted products will be removed from the cart and you will not be able to do so. Enter into fresh transaction, upload products, participate in bids. If already participate in the ongoing bids, will be withdrawn. Carted products will be taken out. However, you will be able to complete the transaction, finalize, and such delivery, payment, receipt, etc., etc. Millard, there was a contract. There was a Millard tender issued by respondent number 8. In terms of the said tender, Millard, we had to supply, Millard, certain quantity of silico-manganese in 3 trenches, Millard. That was my offer. That's an admitted position. Millard, the offer, Millard, which came back, Millard.
1 minute. There is an appellate provision. Why are you not availing that?
Millard, kindly, Millard, looks, Millard, it's, Millard, completely, Millard, I had given a protest letter. It's completely without jurisdiction because, Millard, I do not know, Millard, that even my response is not considered.
No, the response will be considered. Show that
Kindly, Millard,
policy, it is over there. Incident management policy.
Yes, kindly, Millard, takes, Millard. Millard, it's not annexed, Millard. Kindly takes, Millard, just one thing, Millard. I had given a response.
Where? Response to this?
No, I had given a response as a show cause notice.
Where is the show cause?
Yes, kindly have a look at the show cause notice, which is at page 94 of your lordship's brief.
But then the appellate authority acts only after penalty is imposed, not prior thereto.
Yes, it's nothing, Millard. Today,
So
Millard,
today there is a penalty.
Millard, the locking.
You apply for
Millard,
appeal.
I bow down. Kindly takes page 94.
Yes.
This is a show cause notice.
Right.
I give a reply at 95. There is
Yes.
no reflection in the order.
No, they are not reflecting it.
They are not reflecting in
In
nothing.
none of the orders
None,
it is
Millard,
there.
it is, Millard, blocked for 2 years to come,
Yes,
Millard.
yes. There's a
Provided-
provision for appeal.
Millard,
Where is that?
My lord, we have, this is completely untrue.
Untrue.
Specifically dealt with his
Where?
objection, kindly comes to page 99.
Yes,
99.
Yes, kindly have a look at 99.
Where is your appellate provision?
You have is, my lord.
Page
At
9,
96.
96,
My
Millard.
lord, proceed at page 99.
Yes,
please
kindly have a
we
look.
have dealt with the show cause.
You've dealt with.
I have dealt with.
Very well. Now you've issued a penalty, imposed penalty. Show me that incident management policy.
Policy, my lord, I am carrying, my lord. In status petition, my lord, it was there
It was annexed. Today, this is not.
today.
So you keep a copy with you always. You never know in which matter it will be annexed and in which matter it won't
Page
be there.
99, Lordship takes, my lord.
This is my lord.
Dekhi,
Policy.
please come.
A copy though.
The petitioner is aggrieved by the penalty
Penalty
imposed.
is at, page 12. When it comes to page 12, the provision for appeal.
Provision for appeal. You must have opened it over here on a page 8. Khule dilo keno?
Which, my lord, I have opened a wrong page, my lord. That was for the offense, my lord, under which, my lord, they have been charged.
Yes, provision for appeal. Pradeep,
বলে দিচ্ছে
কি বললাম? Imposed by GEM. Suspending the transaction of the petitioner for a period of 730 days. Starting from 27th March
Millard,
2025
this is Millard, one
to
thing. Millard.
27th
Lordship,
March
yes.
2027.
Millard, there is no contract. I have not, there is no contract. This comes it provided there is a contract.
No.
My lord,
Kindly takes the policy in question. There is no
Yes.
contract. Millard kindly takes the, that's my
This
point.
is how the incident management is
Yes,
taking
correct.
place.
Provided there is a contract. Millard, I go to a portal. Millard, this kindly Millard appreciates. I go
Yes.
to a portal. A contract is entered into.
Not necessarily.
Millard, the contract is not entered into.
Contract is not entered.
Millard, by between Visakhapatnam and me, Millard, and he gives a contract, Millard, is not entered into.
Yes.
Millard, whether this will come into effect at all or not, Millard.
My lord,
That is,
my
Millard, that
colleague
is,
said-
Millard, Millard, kindly bear with me, Millard. Kindly, you will have your say. Millard, there is no contract. I give Millard a bid. The bid, Millard, they place. I don't accept it. They say it's a contract has come into force. Is it, Millard, the part of the contract? Yes, this
Had
applies.
the contract come into force, then your allegation would have been against that Visakhapatnam authority,
Also,
not against GEM.
It's what? It's Millard, GEM Millard. It
It
gives
is
a
just
policy.
a portal.
It's just a portal. Now, Millard, there's a
It's
portal
a
operate.
marketplace where you go and do your
Yes,
business.
Yes, I do the business. Millard, the business that did not fructify. Does that not fructify? Millard,
See, the allegation is that you did not pay the transaction
Yes.
charges.
yes. Millard, transaction charges are payable provided there's a contract. I get the contract from the portal. That is this.
And you say this issue cannot be raised in the
Millard, how,
appeal.
Millard, there is, I am not bound. Millard, there has to be, Millard, three parties. GEM, me and Visakhapatnam.
No, Visakhapatnam is not there now.
Not there. Visakhapatnam gives me, Millard, places a, Millard, purchase order, Millard, on me, Millard, which is variation with the original term of the offer. Also, Millard, the term of the offer is divergent from the Visakhapatnam order.
All
Where
right.
is the contract for enforcement of these rules in question? That is the case. Kindly, Millard, takes the petition once. There is variation from the offer of Millard, the order of Millard, Visakhapatnam, offer of Millard, GEM. He can enforce it provided there is a contract.
Do you have the incident management, this thing? Have you gone through it?
I have, Millard, kindly look, Millard.
Please come to page number 3,
Yes.
introduction.
Page 3 आगे हो.
It mentions about the offer.
Yes.
It mentions about
Correct, Millard, correct.
an
Absolutely.
offer, and it is there that the term deviation is mentioned.
Yes. Millard, offer acceptance contract. It mentions that, Millard. Now, Millard, I have immediately raised a complaint. Whether I go to the appeal court or not. Lordship sees the documents in question. Millard, the transaction fees is imposed when there is no contract between the parties.
The writ court will certainly not enter into all these things. If
On
you
the-
want,
Millard,
I can direct you. You can approach the civil court and get it done. But the writ court is not going to see whether everything you've done in accordance with.
No,
It is
only
their
one document.
transaction fee. You've paid, not paid. It is for them to decide. Please come. On and from এত to এত ঠিক আছে the order of penalty mentions that during this period the carted product of the petitioner, if any, will be removed from the cart, and the petitioner will not be able to enter into fresh transactions, upload products, participate in bids /RA caps. And the carted products will be taken out. Step. The bids in which the petitioner already participated will be withdrawn. Stop. The petitioner has been permitted to complete the transactions already finalized. Stop paragraph. The petitioner submits that the response which the petitioner made to the show cause which was issued to the petitioner was not considered by GEM, G or M caps E small. Stop. The impugned order of penalty does not disclose, and there is no reflection at all with regard to the manner in which the response of the petitioner to the show cause has been considered. Paragraph. Prayer has been made to set aside the impugned order of penalty. Stop. Learned advocate representing GEM submits that the reply to the show cause filed by the petitioner was duly considered, and it is only thereafter that the penalty has been imposed. Stop. The incident management policy of government e-marketplace has been placed before this court in support of the submission that there is a provision for appeal against the imposition of penalty. Stop paragraph. It appears that clause 8 of the incident management policy prescribes that the option of appeal can be availed by the seller /SP after imposition of penalty. Step. In the instant case, penalty has been imposed upon the petitioner, and it will be open for the petitioner to avail the remedy of appeal as prescribed in the incident management policy. Stop. The writ petition stands disposed of.
One small prayer, Manoj. Manoj, kindly the name of the respondent number 2 to 7 be expunged. Manoj, they are the one of direct extra. They have been made parties by their individual names. Manoj, James is there. Manoj, James is taking responsibility. 2 to 7, Manoj.
Why the persons have been impleaded by name?
No
Lordship will
pleading
delete
as
it.
to what
Lordship
they
will
have
delete
done.
it. Lordship will delete it.
Acha. Respondent number 10 is the government marketplace and is being represented by the learned advocate. Stop. The officers of the respondent number 10, being the respondent numbers 2 to 7, have been impleaded by name. Stop. As there is no personal allegation against any of the respondent numbers 2 to 7, accordingly, their names stand deleted from the cause title of the writ petition.
I'm so grateful.
Pradeep, এটা কি লাগবে? Take this back and keep it with you. Or I can keep it with me also.
But I will give you a complete copy. Manoj.
All right.
I'll give you. I might have to full copy.
Five to 18.
5 to
19.
19. In between 13 is not that matter.
Oh, 13 is separate.
13 is separate. Only
number 5.
some additional pleadings have
Yes.
been made. Deolasri is aware there are 20 trade
Mr. Bandopadhyay is appearing in this matter also?
Yes, in 4 matters he has been briefed.
Acha, ठीक है. Yes. What is
In
it?
this FCTWEI, they affiliates other trade unions. There are 20 odd trade unions. my lord, unless a particular trade union is affiliated with these, my lord, federations, my lord, nobody can work. My lord, what happened after we agitated, we my lord, protested against the actions, my lord, we were affiliated with these my lord, federations, but now they have not continued the affiliations. My lord, it has several consequences. Now, any member of, my lord, this Director Association of Eastern India, my lord, he will not be able to work because the other my lord, technicians who are also, my lord, guild members and affiliated with the federation, they will not act because I will be outside the federations. My lord, that is the problem they are creating. Now, another aspect, there is a film directorate of the government of West Bengal, right, which controls everything virtually. Even they provide medical insurance to the members of a particular trade union and through these federations. Now, all these DAE members, who were somehow not affluent, they were being provided with the medical insurance. But after this, now they have stopped because the respondent number 5 is not forwarding their names since their affiliation has not been continued. I have pleaded. Kindly take the pleadings from paragraph 25 onwards.
1 minute. You mentioned about a film directorate. Is the film directorate?
No, film directorate is not a party, my lord. I have got it, my lord. I have just searched it, my lord. I can hand over this copy, my lord.
Is it a government body?
Government body. Created by the government.
Created by the government.
Government. And it is headed by, my lord, one WBCS officer. It provides, kindly take paragraph 5. This is medical insurance. There are other functions also.
Why don't you implement the directorate as party so that necessary?
I should have. I'll kindly grant me leave. Only thing, kindly see my pleadings, from paragraph 25, because I need, just extra bit of directions, paragraph 25.
Yes.
Since last few years, the respondent number 1, that is the state government, has been providing health insurance policy to the members of DAE along with the members of other trade unions engaged in the film and television industry. The practice corresponds to such health insurance policy being afforded by the respondent number 1 by virtue of the submission of credential and particulars of the members of DAE through respondent number 5. The respondent number 5 has now refused to forward the names of the members of DAEI to the office of the respondent number 1 for the issuance of the health insurance policy to the members of DAEI. This act of reprisal is both unjust and detrimental to the well-being of the members of DAEI who rely on these benefits for essential security. Despite being
1 minute. Let me understand. Respondent number 1 is giving the benefit through the respondent number 5.
Yes,
only
because
if
the
the
names
respondent number 5 is forwards the name, then only you
then.
get the benefit. Otherwise, you
No,
won't.
these are the health cards.
Can you not approach the respondent number 1 directly? You cannot approach the respondent number 1
unless
directly.
These names are forwarded by the respondent number 1, that respondent number 5, the government will not give this medical insurance. In fact, our affiliations has not been extended by the these federations because we filed these writ petitions and also made protest. Our affiliations has not been extended. Now, entire thing is controlled by these federations. It's a syndicate. Kindly see the health insurance which were issued to my members, paragraph page 160.
Where is this recorded that it has to go through the respondent number 5? You cannot do this independently.
This is the system that I have pleaded. Kindly take
Nothing is there, my lord, on record.
I'll permit you to directly go before the authority.
Yes, them directly go before the state authority.
The authority
There is
will
no
consider.
such, nothing is annexed to the writ petition also in regard to this. Respondent number 5.
Very well. He says it is no.
Yes, kindly record.
I'll record.
Yes, that will do. My lord, that will do, my lord.
What else?
Another thing is, my lord, kindly take prayer K. Your lordship already given the protections, but my lord, in the light of prayer K. Same, your lordship has.
What is this unique card?
Unique card is, my lord, this unique card is also issued by the federations, my lord, because there are 20 affiliate, my lord, trade unions. There are cine workers, artists, the stage workers.
Whatever.
So now, this if there is no unique card issued, Well, nobody will work. Nobody will be able to work with anybody unless there is an unique card issued by federation.
Who has given the federation this power to issue
Nobody,
this
they
unique
have
card?
assumed this jurisdiction. They have, this is the code of conduct, they have issued. Kindly take code of conduct I have annexed. This is the code of conduct. They have kindly take page
39.
46, my lord. Clause 2, right hand side, my lord, page 46, clause 2. Right hand side, my lord. One is also the other conditions. My lord, without following this, nobody can work. Kindly 2, technician workers must carry the membership card to be issued by the affiliate trade union of FCTWEI. Quantum for the new members, future membership, all new members shall be determined beginning every year by JCC, FCTWEI and EIMP. So this is unique card. But they must carry it, otherwise they will not be, not only they will not be provided any work, if I wish as the director, I cannot, they cannot work for me, then I will be suspended. And this has happened, my lord. I have given the instances, my lord, just the Kaushik Ganguly, Srijit Roy, my lord, their works have been stopped in February, in March. I have given the, my lord, I have pleaded also.
Yes, what else?
This code of
Anything else?
conduct,
And the other portions of the order that
That will
has
remain.
passed in.
this code of conduct was effective for only 3 years.
No,
my
no,
lord.
this
Kindly
has
takes
been-
up page 67 of the writ petition.
This
Page
continues.
67.
No, page 46, it is very
46
clear.
it starts, the code of
Continue.
conduct starts from page 46.
You say it is not valid now?
No,
I'll
page
record it.
67, page
I'll
67,
record it in the order.
page 67 kindly,
I will record in the order
page 67 it is,
that this is not effective and you cannot press this upon the.
because my lord,
No, because you
because
say
in
yes
page,
or no.
Page 67, because in page 67, paragraph number 20, it is clearly stated that the said code of conduct will be applicable for 3 years. It is to be noted that the clause and subclause of the code can be changed as per the need. Page 67 kindly takes up.
Kindly take 21. This is the parent
What my
code of
learned senior friend is referring, that was effective for 3 years.
Now it is no longer valid.
That I can file an affidavit.
No,
in that
you
regard.
say.
No, because my lord, as per the record of the writ petition, my lord, my respectful submission.
Why?
Because I have to, then your lordship kindly gives us an opportunity to file an affidavit. I will.
That is separate. But as of now, are you implementing this?
This code was valid for only 3 years.
All right.
3 years. That is that your lordship can record.
He is referring, these are the additional obligations imposed by the subsequent
Code was effective for 3 years, my lord.
Please come. And who has given you this authority to come up with this code?
No, that
What authority do you have?
That was in 2015, my lord. That
Why?
I could
Who
take
gave you the
instruction.
authority?
In regard to that time, what happened in 2015, that I would be candid before your lordship. I do not have that instruction. That I have to bring the instruction in 2015, my lord. Because this code of conduct was effected since 2012 to 2015, my lord. Not presently, there is no code of conduct, my lord.
You are a private entity.
That was-
Absolutely private entity. You do not have any right to impose any condition upon any of the members.
This was, my lord, in 2012, my lord.
Whoever, 2012, you had extra powers?
No, my lord,
Then?
that is true. But today it is not in effect. my lord.
Today it has been brought to the light of the court.
Today it is not in effect, my lord. 2012 to 15 it was there.
Please take down. Item number 2, some order has been passed. Data thagbe. In addition to that, the petitioner, how many? There is one.
One, my lord, each of
All right. The petitioner has annexed. A document described as, within single quotes, code of conduct of the technicians and workers of Eastern India, agreed and adopted at the joint meeting of the Eastern India Motion Picture Association and Federation of Cine Technicians and Workers of Eastern India. Stop. In the said code of conduct, it has been mentioned that the technicians / workers must carry the membership card to be issued by the affiliated craft union of FCTWEI. Stop. The quantum of percentage for new membership, that is future membership, will be taken and determined in the beginning of every year. Stop. The document mentions that the same is effective only from 1st May 2012 to 30th April 2015. Stop. Paragraph. Learned advocate for the petitioner submits that the state is providing health insurance policy to the members of the, what is DAEI?
All persons followed, including the members of Directors Association of India, Eastern India.
Members of the Directors Association of Eastern India.
We have annexed certain.
Along with members of other trade unions engaged in the film and television industry in West Bengal. The health insurance benefit is provided only after the credentials of the particular members are routed through the respondent number 5, that is the Federation of Cine Technicians and Workers of Eastern India, to the respondent number 1. Stop. The respondent number 1 does not accept any request from the members directly. Stop. Paragraph. Learned advocate representing the respondent number 5 submits that the said code of conduct was valid only for a particular period of time. Stop. The same is not being made applicable at present. Stop. It has also been submitted that the respondent number 5 is not interfering with the functioning of the petitioner. Stop. Paragraph. Learned advocate for the petitioner submits that there is a directorate of,
the film directorate.
there is a film directorate
Respondent number 4 is the concerned person. You also will find it.
headed by the additional secretary.
Yes, yes. Mother.
Headed film directorate, headed by the additional secretary and the executive officer, comma, director of films, being the respondent number 4. Stop. Paragraph. And then the rest portion of order to item number 2 will follow.
Only in that item, there is a can for under that.
Can will not be here.
So mentality may be kept token.
We ordered the তুলে নেবেন. Same order will be there in
You
item
have
number
permitted
6.
the respondent number 1 to issue health insurance directly.
আচ্ছা আমি বলে দিচ্ছি.
That
The as the respondent number 5 is a private entity and the petitioner alleges that the respondent number 5 is standing in the way of the petitioner in performing his activities and is infringing upon the fundamental right. Accordingly, the court permits the petitioner to approach the state respondents directly without routing the application through the respondent number 5. Stop. In the event any such application is made by the petitioner, comma, the same shall be considered by the state respondents without directing the petitioner to approach the private respondent number 5. Anything else?
Yes, my lord, only unique card, they are saying that the code is, that still it
Code is not.
my lord, that is, my lord,
একটা জিনিস লিখে দিন তো, the
still it is,
petitioner
my lord, is being forced upon.
submits that the respondent number 5 is insisting upon the petitioner to obtain the unique card.
No, my lord, it is the case that this unique card to be obtained by all workers, everybody. My lord, if, my lord, these members of DAE do not get, my lord, other will not work for him. So that should be, since they are saying this
আচ্ছা,
code
তাহলে
of
একটা জিনিস,
conduct is not sufficient, my lord, that should be abolished.
হ্যাঁ, একটা জিনিস বলুন, it has been submitted, it has been alleged that the respondent number 5 is insisting upon the unique card for effective functioning of the petitioner stuff, as the respondent number 5 has mentioned that the code of conduct was only for a particular period. Accordingly, the respondent number 5, accordingly, non-production of the unique card will not affect any of the rights of the petitioner to perform his duties and functions as director. This will do possibly. 6, same order will go. You are there. Same parties. State,
My lord,
you are there. 6, Mr. Where is he? Anybody assisting him?
It is 6.
Nobody is there. Give his name. 7. State. State.
5. It is 6.
None for the state. 8. Anybody there for the state? Where are they?
7. 8.
Where are they? Another courtroom. How can the name be recorded?
8. 8. I'm check.
দিয়ে দিন।
9.
9. Yes. 10.
10.
Yes, please. 11. 12.
11.
13 is not
14.
my matter. 14.
Give your name. 15.
30.
Yes. 16.
14. It is 14.
Slips handed over. 17.
একটু মিলিয়ে নেবেন, হ্যাঁ, cost title.
18. 19. All right. Call item 13.
18 and 19.
13 I appear for the response. And
I am on behalf of the petitioner.
the 19.
13.
Yes,
I appear
Lordship.
for the response.
Lordship, I am appearing on behalf of the petitioner, Lordship. Lordship, in earlier occasion, Lordship, regarding the election of the Pharmacy Council, Lordship, I had appeared, and definitely, Lordship, being a newcomer, Lordship, initially I understand that why Rabindranath Tagore said, "Bicharer bari nirobe niprite kaঁদে," Lordship.
Do not go to
Lordship,
all these things. Come to the facts of the
I am
case.
coming, Lordship.
Yes.
Lordship, I am coming here, Lordship, again for the pair of the staying the further proceeding of the election procedure, Lordship. Lordship, need to declare the null and void of this election. If you consider the issue of the register, Lordship, you may declare
Yesterday you were mentioning that the registrar is fake or something.
Yes, Lordship.
Where
I am-
is the documents?
Lordship, I am coming, Lordship. Not only that, Lordship, there is other several grounds, Lordship.
Come to that ground first. Fake.
Okay, Lordship. Lordship, kindly consider the page number 98, Lordship.
Yes. You have sought for information under the Right to Information Act.
Someone is sought, Lordship.
Not you, Shama Prasad Das.
Yes,
You are
Lordship.
Shimanta Bhattacharjee. All right.
Lordship, kindly consider the questions in this RTI, Lordship.
When did the
When
Department
did
of
the
Health
Department of
appoint-
Health and Family Welfare, Government of West Bengal, appoint the Register of West Bengal Pharmacy Council following the Pharmacy Act 1948? Question mark. Kindly mention the memo number of the appointment order of the Register of the West Bengal Pharmacy Council? Question mark. Next, kindly furnish the appointment order of the Register of West Bengal Pharmacy Council issued by the Department of Health and Family Welfare, Government of West Bengal. They did not send the reply after in appellate authority. Lordship, kindly consider the page number 101, Lordship. 101. Just turn over the page, Lordship. 101.
Yes.
The reply is number 1, on the basis of the question, Department of Health and Family Welfare, Government of West Bengal does not appoint the Register of the West Bengal Pharmacy Council. Number 2, not applicable. Signed by this register, Lordship, who is holding this post as claimed, Lordship. Lordship, as per section 26, Lordship, of the Pharmacy Act 1948, Lordship, there is need a previous sanctions of the state government. Just one line, Lordship. As per section 26, staff remunerations and allowances, the state council may, with the previous sanction of the state government, appoint a register who shall also act as secretary and, if so decided, by the state council, treasurer of the state council. So, Lordship, the department did not provide any letter, any appointment letter as per this record, Lordship. So, Lordship, this is the prima facie case, definitely, Lordship, that who is conducting these elections as a returning officer also. If he is standing in this way, how this election is proceed and is it legal in the eye of the law? There has no any existence, Lordship. So that's why I am praying before you, Lordship. The entire election procedure, along with others grounds, Lordship, only this ground is sufficient to declare the entire procedure as void ab initio, Lordship.
Who is the authority to conduct the election of the Pharmacy Council?
Lordship, the returning officer, who is the registered by post.
The registrar may not have been appointed by the Department of Health and Family Welfare. Somebody else must be the appointing authority.
They did not provide any. There is a specific clearly mentioned here. There is a need of previous sanction of the state government. We are asking for that. To who appointed him? Nothing is come in our hands, Lordship. And Lordship, kindly consider Lordship, page 117, Lordship. Similar question asked by someone, Lordship, through RTI.
Yes, I'm coming. Page
Lordship,
117.
Yes, Lordship.
What is
Here
that?
also, that when did the Register of West Bengal Pharmacy Council was appointed? If so, then kindly provide the copy of appointment of the Register of West Bengal Pharmacy Council. Same question. Kindly, so the concerned authority did not provide any information. They are not able to provide anything because there is no any legal existence.
Oh, what is the order that your learned senior friend is referring to? Which page?
That was your previous order, Lordship. I am
Yes,
telling you.
page 57, 54. 54. The election was conducted in accordance with the division bench's order.
Yes, Lordship.
Right, an observer will be there for ensuring that the election is free and fair. Did you forward your objection to the observer?
Yes, Lordship.
You did. What happened thereafter?
Lordship, kindly look at para number 8, Lordship.
Observer passed an order.
Lordship, kindly
That's at
page
page 9.
55, Lordship. Para number 8, Lordship.
Yes.
The petitioner prays for conducting an inquiry as there are gross illegality in the election process. That means we want an inquiry. On that basis, you have passed the necessary order, Lordship, and you have passed that the objection should be disposed prior to the dispose of the declaring a voting result, Lordship. Now, Lordship, I am.
Where is the order of the observer?
Lordship, I am coming, Lordship.
90.
90.
90.
Where is your objection?
Lordship, I am. Lordship, my objection is page 58, Lordship.
50.
It was the objection.
And did you forward the pen drive that you intended?
Yes, Lordship. Yes, Lordship. 58.
All right, 58 and 59 is your objection.
Yes, Lordship. On dated, Lordship, December 2024.
18 December, yes.
Yes, Lordship. Now, Lordship, this kindly remind the fact that on next day was the counting procedure. Being a candidate, Lordship, I was present at the office. And I have some responsibility to observe all the proceeding and supervise my election agent. On that day, the returning officer called at his office room where the observer was present, and returning officer said they are ready to hearing as per your order immediately. Now, then the petitioner said, no, it's not possible because now the election counting has started, so I have to follow that only. Kindly fix the appropriate time, at least 48 hours prior to the hearing, and my advocate will represent my case, Lordship. They did not consider. They provide the first hearing notice, Lordship. After complete the counting proceeding, I email that it's not possible. Why not possible, Lordship? Kindly look at the page 75, Lordship. This is my email, because the representative advocate was at that time at North Bengal at least need 48 hours, Lordship. And on that day was a scheduled activity, counting of the vote.
Paragraph number 2 at page 90 mentions that one learned advocate was present.
No, Lordship, I am 75, Lordship.
75?
So page 75.
Page 90 is the reasoned order.
90 is, I am coming, Lordship. Kindly consider page 75. The situation, the background at this stage, Lordship.
Yes.
Lordship, here I requested for reschedule at least give me the 48 hours.
Where is the notice of hearing? Please show me.
Notice of the hearing, just
yes, page
74, earlier page, Lordship.
All right, hearing
This
notice.
is the
This is
hearing
the
notice.
first hearing notice.
Yes, Lordship. At the date of during the counting of vote, Lordship.
So on 30th of January 25, counting of votes was going on.
Yes, Lordship. At that moment, I received that.
All right.
I just prayed that I
and
have
you
to
are a
add-
candidate also.
Yes,
All
I have
right.
a responsibility to.
All
see
right.
the
Then what
officer.
happened? 30th,
Lordship,
you
next, I just emailed that after in the evening. Then page 76, Lordship. The
Yes.
observer replied me. Reply me and said and make the remarks regarding my behavior, Lordship. How he concluded these things, I do not know. I have objection in this point.
Page 76.
76, Lordship.
where is your behavior?
Sir, next, I will come in, Lordship. This I am coming, Lordship. This
Please
is
take your seat. Please take your seat.
76, Lordship. Here he replied and he did not consider my rescheduled prayer, Lordship.
All
So
right.
naturally, Lordship, on next day, when the time and date has fixed, at that time, Lordship, I filed a time petition because I have no option. The conducting advocate was at that time at North Bengal. So I informed it at page 77, Lordship. Maybe you can consider para number 4, 8, and 10, Lordship. This is my time petition with prayer. Now, Lordship, page 80. Page 80, here he remarks on the basis of my time petition. He remarks that regarding my behavior, I am not cooperating, lackadaisical behavior, etc., etc. I have objection. How he conclude this point, Lordship? So, through advocate, the petitioner sent again an email. Next page, Lordship. If you finish page 80, then next. Next page, Lordship, 81. Where through advocate, Lordship, the petitioner prayed the reason. The advocate stated what is the genuine reason and requested for avoiding legal complexity. Consider the fact and make a reschedule, Lordship. After that, Lordship, the observer issued a second notice, page 84, Lordship. This is the basic background, and mind it, how he considered my prayer time petition and pre-decided his intention regarding towards me, Lordship. This is the second notice, hearing notice. He fixed the matter on 4th February 2025. On that day, Lordship, the petitioner present through his advocate and participated in the proceeding, prayed for inquiry, and where submitted one written note of hearing, Lordship. Page 85. This is the written note of hearing. Here, Lordship, kindly.
Then what happened? Then page 90 came. This is page 90. The reasoned order that has been passed.
Yes, Lordship.
What is it?
Lordship, this is the reasoned order.
How are you aggrieved?
Lordship, firstly, he rejected all the allegations.
Yes.
Secondly, Lordship, they did not consider or investigate or inquiry on the basis of my content of the petition, content of the prima facie supporting documents, basically videos, pictures, and other relevant things. Lordship, I presented my case on that day, and I taking support the allegations with help of this content, this available content. There is need inquiry, need to summon the relevant persons, like who circulate this picture, the candidate who used the logo of the government, logo of the statutory body. Did not the observer did not consider all of these things, Lordship. This was a mere eyewash proceeding, Lordship. Within the four wall, there was a mere eyewash proceeding, Lordship.
Show from the reasoned order.
Lordship, paragraph number 3, Lordship. Paragraph 3. Even he did not consider my video, Lordship. Whatever I have mentioned in it has already mentioned in my written note of hearing in a brief way, which are not considered. And last 2-3 points, Lordship.
Now, what is the position? The election is over.
Election is over.
Yes.
They will go to make the constitute the executive body, Lordship.
Yes.
So, Lordship, here some need to 2-3 facts, Lordship.
We will look at the facts after all.
No.
Later on.
Lordship.
Ashunto.
Lordship, there are so many other grounds, Lordship.
The reasoned order, I'll hear you. The reasoned order.
Lordship.
Dated 4th of February.
There is the allegations of the theft of the ballot paper. Issue.
Joint Secretary.
Okay, Lordship.
comma, Health and Family Welfare Department, Government of West Bengal, and the observer for the West Bengal Pharmacy Council general election is impugned in the instant writ petition. Stop. The petitioner has raised various issues. Stop. The matter is required to be heard. Stop. Let affidavit in opposition be filed within a period of 4 weeks.
Yes.
Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing.
Lord, I'm raising
Lordship,
a
kindly stay the
point of
procedure, Lordship.
tenability of the writ petition because Lord, he is challenging the election. And
Lord,
there is a
the
procedure prescribed for
issue
challenging.
of maintainability of the writ petition has been raised by the respondents. Stop.
Lordship, which is already discussed in the division bench,
The
Lordship. I adapt that.
said
This division
point is
judgment
left
is what
open
we are relying
to be
upon.
decided at the time of final hearing of the writ petition.
Lordship, kindly stay the further proceeding, Lordship.
Any steps taken pursuant to the election shall
Lord,
abide by the result of the writ
Elected
petition.
members, Lord,
Much obliged.
they are going to function. Lord.
Let them
Your Lordship,
function.
next
steps
item.
taken.
Much obliged.
Your Lordship, next item 20.
ও, আজকে আছে? কি করবেন?
Your Lordship, next item being item
Huh?
item number 20. Signed matter, Your Lordship. This has been assigned to Your Lordship's court yesterday. Your Lordship, the interim order is expiring tomorrow on 4th of April. Your Lordship,
Taken up.
if it will be there in the list, Your Lordship.
It
at
is
the
in
top.
the list.
Very
It
well, Your
has
Lordship.
been tagged with item 21 and 22. 21 is my matter, that Mandamani matter, Millard.
Demolition
Millard,
of hotels.
Millard, I was praying, can the matter be taken up on Monday, Millard?
Then his
Yeah.
interim order will, doesn't matter, extend your interim
Lordship
order.
kindly extends the interim order.
And moreover, even if I do not extend, nobody is taking any problem. Nobody is
there is
creating
already
any
interim
problem.
order.
The respondents are supporting
Your
all.
Lordship, may kindly formally extend the interim order, take it up whenever convenient, Your Lordship. Your Lordship, Your Lordship, my client is apprehensive. Your Lordship, formal order, so I have no objections. Can keep
Your
it on
interim
Monday.
order is valid till
30th of April, Your Lordship, I am carrying the order.
30th of April.
Lordship, I am carrying the order. Lordship, there are 3 matters tagged together.
দেখি
এই order টা
অর্ডারটা দিন।
Item 20 has been recently tagged with this.
No, he said yesterday it was tagged. কবে সেটা?
Lordship, yesterday. It's expiring on 30th of April. Should be, since it's tagged, Your Lordship, let this also be extended till that date.
Who is your other side?
Lordship, in this matter, Your Lordship,
Item
Mr.
20.
20.
Did you make the respondents aware that it has been assigned?
Your Lordship, we
didn't,
have issued a letter to the Chief Justice pursuant to the
No, that is for assignment. But
Lordship.
then after assignment, you did not.
Lordship,
Come
after
tomorrow.
Your Lordship, yesterday it was assigned, so
Yes, so it's better you serve notice. It is there till tomorrow. Tomorrow I'll see what is
very
to be
well,
done.
Lordship.
And your prayer I'll take into consideration tomorrow.
Very well, Lordship. Grateful.
Lordship, kindly mention the server copy. I can communicate with the.
Yes, server copy
Kindly-
will be there.
Kindly note down.
Yes.
The old contempt matter will be taken up at 2 p.m.
No, possibly it won't be taken up today.
Tomorrow.
I'll take up the applications.
Lord, I cannot wait till tomorrow. Extremely urgent matter, Lord. Work order will be issued tomorrow. It's in the monthly list I filed, Lord. Kindly give some precedent, otherwise it will become infructuous. But
Why are
work
you
order shall,
mentioning now? The matter is there in the monthly list.
Lord, if it is not taken up tomorrow, the work order shall be issued. Lord, the
Oh.
tender matter will become infructuous.
Yes.
Lord,
What
give
can
me
be
some
done?
time tomorrow, Lord. Otherwise, Lord, the writ petition will become infructuous.
Why was it not mentioned earlier?
I mentioned, my Lord, then, Lord, kindly.
Did
then,
not allow.
then
And now
work
the
order-
court
then
will
the
allow.
work order was not there, Lord. Today financial bid open yesterday. Tomorrow the work order will come. Then
Yes.
nothing would remain, Lord. Kindly let me come back, Lord.
Who
Tomorrow
is
any
your other side? Which authority?
state. Item 375 of the combined list, Lord.
কালকে দিয়ে দিন তো 375 upgraded motion, urgent motion.
So grateful.
And serve notice, ensure the service upon the other side.
375. I'm so grateful to you.
This matter, the chairman.
The
chairman.
Uh-huh.
He has been changed, and now new chairman has come.
My lord, I appear for the ex-chairman.
All right.
My lord, rule was issued on the, my lord, the order was on the municipality to pay the amount. My lord, at that point of time, I was the chairman. My lord, I have paid a part of the amount by your lord. It's recorded in your lordship's order as well. But after that, your lordship, my lord, I have been changed. My lord, I have, my lord, may I submit my...
Was it not your duty to intimate the court that yes, there has been a change?
My lord, on the last occasion, I could not present myself before your lordship. I was not
That is
aware.
the reason the rule has been issued.
Yes, I was not
done?
aware, your lordship. Thereafter,
Nothing
my
can
lord,
be done. Is the person present?
no, my lord, no.
Why? Rule has been issued, the person will not be present.
No, my lord, there was no personal appearance given, my lord. Only, my lord, I have filed a compliance of the lordship's, my lord, order. Compliance affidavit of your lordship's order, my lord, that why I could not pay because I was, my lord, removed from the post of the chairman.
There was no personal appearance?
No.
Sure.
Yes, my lord. My lord, yes, to that.
Only rule was issued.
Only rule was issued. Rule was made returnable on today.
What does rule issuance of rule mean? What does issuance of rule mean?
My lord, issuance of rule means the person has to come before your lordship has to, my lord, satisfy your lordship on the compliance of the order.
That means the person has to personally come, and it is recorded in the rule that personal appearance has to be there. And you say the person was not directed to come?
No, my lord, it was not recorded in your lordship's order. If your lordship kindly sees the last order, what I found from the...
The rule has been issued and he has received it.
No, he has not received it, my lord. My lord, kindly, my lord, the sees, my lord, the rule was issued, my lord, has to go to the municipality. My lord, he is no longer, my lord, eligible to enter the municipality and the rule was not served upon him. I came to know from the order passed by your lordship that there was a rule issued, and my lord, I find it to be my duty, my lord, to file an affidavit of compliance to that effect.
The rule addressed to the chairman has been received by the office of the Mal Municipality.
Yes, my lord, not by me. I have not received it. I have gone through the order and then, my lord, I came.
What about the compliance?
My lord, part compliance was done.
That was long back.
Yes, long back.
Thereafter?
After that, I could not, my lord, comply because of paucity of funds. I have stated in my earlier order as well. That was
Paucity
recorded
of
in the order.
funds. You disclose the assets of the
My lord,
erstwhile chairman. Please come.
My lord, I am, my lord, the chairman. Today, my lord, the new chairman has been appointed, your lordship.
The rule which was issued upon Shapun Shaha, chairman
My lord,
of Mal
kindly sees
Municipality.
the order of the writ court, my lord, once. My lord, the payment was made
Was-
on the municipality and not on the
was-
chairman, your lordship.
Was received by the office of the Mal Municipality, as the said chairman has since been removed
On 31st of January, your lordship.
on 31st January 2025.
Yes.
Stop. Next.
And my lord, the new chairman has been appointed on, my lord,
The-
7th of February 2025.
It has been submitted by the learned advocate representing the erstwhile chairman that a new chairman has been appointed.
Yes.
on 7th February 2025.
My lord, it's there in the affidavit of compliance which I have filed before your lordship.
The paragraph, the order of the court is yet to be complied with. Stop. Partial payment has been made by the municipality. The balance is pending for a considerable period of time. Stop. Next. The municipality would be bound to pay the dues of the petitioner. Stop. Next. Leave is granted to the advocate on record of the petitioner to implead the present chairman as contemptor in the instant contempt application and serve a copy of the contempt application and all related papers to the added respondent. Stop. Next. As it appears that the erstwhile contemptor was at the helm of the affairs when the order was passed by the court, and he was bound to comply the same. Accordingly, the chairman, Shri Shapon Shah, the erstwhile chairman of Mal Municipality, is directed to file an affidavit of assets disclosing his assets before this court. Stop. Next. The matter is made returnable on 15th of May 2025.
My lord, only one thing may I point out to your lordship?
Affidavit of compliance. Affirmed by Shapon Shah on 28th March 2025 be written with the records.
My lord, may I point out one thing, my lord, from your lordship's order only? My lord, the direction was absolutely, my lord, on the municipality and not on the chairman, my lord, to release the funds.
Call the next matter, please.
My lord, the rule will remain, your lordship.
The rule has already been served. So what
No,
is
it was not served upon me.
upon the office? It has been served.
Yes,
it has
so-
been accepted. It will be there.
My lord, then in that case, my lord, the ex-chairman, my lord, had to be personally present before your lordship on the next day. My lord, let that rule be dispensed with. In the meantime, if your lordship so desires, I'll file my affidavit of asset, my lord.
No, you filed that affidavit of assets. একটা জিনিস লিখে নিন তো যে since the contempt rule was personally not received by the erstwhile chairman, accordingly, his personal appearance stands dispensed with for the time being.
Deeply obliged, your lordship.
But the petition was. But in the morning, I mentioned that 488 and 489.
Please wait. Yes.
Content application. Stay back.
Who is the contemptor?
Pradhan bhai.
Pradhan. Is the person still there? Or has he changed? Present. None represents the respondents. What happened to the hearing which was fixed on the 10th? Nothing happened. Hearing took place or not? Hearing took place.
Yesterday it's fixed.
Yesterday,
Second day will again fixed.
what happened on 2nd? Nothing. A learned advocate for the petitioner submits that The hearing which was scheduled on 10th March 2025 did take place, and hearing was rescheduled on 2nd April 2025. Stop. On that day also hearing took place, but final order is yet to be passed. Stop. Paragraph none appears on behalf of the respondent. Contemptor. Stop. Let contempt rule be issued against Shapna Das seat, the present Pradhan of the Grand Panchayat, returnable on 15th of May. Acha, একটা line. The requisites to be put in at once.
At 4:37, I paid for only adjournment, my lord.
Why?
Yeah, for Philip Tushari, he is ill, my lord. Today he has not come to the court.
Last occasion also it was adjournment on his prayer. And there is
Yes.
no contempt, Lord. If I may respectfully submit, there is no contempt.
No contempt.
I am not for the contempt, Lord. I am for the applicants in the writ petition, but added party, my lord. There is no contempt because your lordship's order, when they have heard, my lord, he was absent during the hearing on both occasions. That's also recorded, and his order has been passed. So if he's aggrieved, you should file a separate proceeding.
Where is the municipality? You are the added party
Lordship, in the writ petition.
in the writ petition.
Yes, because my construction is under
Under
question,
challenge.
lordship. And I have filed a partition suit, my lord, and this is civil court.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. It appears that on earlier occasion also, the matter stood adjourned at the instance of the petitioner. Stop. Paragraph from the documents of the contempt application, it appears that the Board of Councillors of Tamrolipto Municipality passed a reasoned order on, what is the date?
My lord,
24th of February 2025.
yes.
Paragraph. The petitioner appears to be aggrieved with the same. Stop. Next. It will be open for the petitioner to challenge the legality and validity of the order of the municipality before the competent forum in accordance with law, if so advised. Stop. There is no requirement of keeping the contempt application pending any further. Contempt stands disposed of.
Okay. Obliged. Naam diye chukka.
I am for the petition.
Yes.
This is that
438.
matter pertaining to water connection, my lord. The Shilpo Kanun Housing Society, my lord, had granted water connection to the housing society, and my lord kindly sees the order dated 22/2025 passed by your lordship, my lord. Till date, my lord, 4 persons didn't get any water connection. Till date.
Now let me say.
Kindly see
Let me
paragraph
say.
4, my lord, of the order.
All right.
We had
My lord,
hands
regard
up
to
to
4
Mr.
persons.
Yes, 4 persons. They cannot show any identity of their being member of the association.
Is there any
Numerous times, yes, there is communication. That is communication. I am showing that communication. Why are not they attending? Let them come at any date. Why not they fix any date, any time?
We have to show them our membership.
Yes.
We shall show.
But let them show, but in any date and time.
Because every time they're taking up new.
I asked him to take
Any date and time, my lord.
water
That should
connection
end.
is yet
When we
to
have
be
given the others, why should we
given
give, will not give the
to
others?
the
Them.
4 persons. Stop. The learned advocate
403.
representing the Durgapur Municipal
403.
Corporation submits that repeated
Clear code, 3
requests
and 4.
were made to the said 4 persons for production of documents in support of the membership.
And repeatedly.
We have my stand is not that we have submitted. That is the instruction. These are the documents.
Let them go, date,
So
time,
if
submit,
they are
receive.
If they are saying so, my lord, I'll again submit.
Acha.
Any time and date may be fixed.
Learned advocate representing the petitioner, Mr. Banerjee petitioners, submits that all documents in support of the membership of the 4 petitioners were produced before the
I deny that.
corporation. Stop. Next. The the petitioners are directed to produce their documents before the municipality within a week.
Corporation.
Within a week, municipality, the corporation.
And any time and date may be given. We are ready. We are ready.
Within a week. Within a week. Stop. Next. The corporation shall take steps in response thereto immediately thereafter. Stop. The contempt is made returnable on 22nd May.
They have given 23 memberships. Now they are saying that there is only 5 membership and this is 4-9.
Next. Yes, 439.
I beg to appear for the petition.
Yes.
Your lordships kindly have a look of your lordships order on 20th March 20.
Demolition not done?
Lord, we have demolished.
No. I have instructions, Lord.
Sure.
They went there, only some tins were removed from the unauthorized construction.
Photographs.
Photographs. Yes, yes, I have.
Please show.
I have all the photographs. There is ask your lordship can look up the sketch map. Wherein they have submitted. This is the document of sketch map. Possibly come to the sketch map first.
Yes, what the petitioner is saying is proper.
May I say, Milord? Admittedly, Milord, there is a plan. I mean, the construction is made in deviation of the plan. So there is no dispute that there is no plan. There is a plan. Now, Milord, the deviation is with a Milord cantilever above the ground floor, Milord. So now what the engineer has, Milord, they have observed if the deviated portion is demolished, the entire building will collapse. Milord, it is reflected in it's a very old building. We cannot, Milord, demolish the.
Where is the report of the engineer?
I will copy that document. I have the sketch map where include the another construction.
Indicated what I have submitted with regard to Milord deviation. I am submitting on instruction, Milord. Recent order was passed, which includes the deviated portion. And the sketch map was Milord handed over to the person responsible for demolition of the unauthorized portion. Now, Milord, we have demolished everything but the deviated part, because if we attempt to demolish the entire thing, the entire building will collapse.
Your lordship will find from that sketch map, Milord, there are 3 portions of unauthorized toilet block.
It has been demolished.
How, Milord, it will be?
Unauthorized toilet block has been demolished.
No,
last portion, Milord.
The tin shed over the toilet block has been removed, but the toilet block is there.
Yes.
See the last line.
Tin shed structure over the toilet of the backside open space has been removed by the
tin shed structure, as that is what he's saying. The tins have been removed,
Very well,
but
Milord.
the structure
I shall,
remains.
Milord, file a report on affidavit, Milord, to this extent, Milord.
Oh no, your report will not do. They have to go and demolish that.
Milord, I am told that it has been demolished, Milord. Kindly, Milord, adjourn
How
this
can you
matter
be
for a
told?
day.
Because your report says something else.
Then may I, Milord, come back on the next date, Milord, with proper instruction whether the actual concrete portion has been demolished.
Please come.
And thereafter also, Milord, left side.
The action taken report by the engineers of the Bidhannagar Municipal Corporation, signed on 26th March 2025, is taken on record. Stop. It appears therefrom that the demolition squad of the Bidhannagar Municipal Corporation visited the place on 25th March 2025, equipped with tools and machinery, along with the police force of the Baguihati police station. Stop. The unauthorized structure was found to be occupied, and the occupiers resisted the demolition and denied to vacate the occupancy. Stop. The front iron gate has been removed and the temporary tin shed over the mandatory open spaces have been removed. Stop. the temporary tin shed over the toilet block has been removed. Stop paragraph. Learned advocate for the petitioner admits that only the tin sheds have been removed, but the actual unauthorized construction still remains. Paragraph. The corporation would be bound to demolish the unauthorized construction. Step. The police will be responsible for vacating the occupants of the unauthorized structure in aid of demolition. Stop. Next. Further affidavit shall be filed. Affidavit of compliance shall be filed on the urgent date. It will be open for the parties to rely upon photographs in support of their respective submission. Stop. The Commissioner, Bidhannagar Police Commissionerate is directed to render adequate police assistance to the men and agents of the corporation at the time of demolition of the unauthorized structure. Returnable on 12th of June.
And will kindly record that certain portion would not be demolished because due to
You write everything in your opposition. Let them go. In
My lord, I'm for the petitioner, my lord.
Yes.
Pursuant to your lordship's direction, my lord, they have given us the offer letter. But there is some difficulty, my lord. It's in eyewash. I tell your lordship the reason.
Offer letter for what?
Offer letter for
Temporary stalls, my lord.
temporary possession. Now, my lord, what has happened is, my lord, we are 9 in numbers. We were occupying the frontal portion of the entire plot. Now they have kept the best portion and the front portion for them. That is more than 60 to 70% of.
But these are all temporary, isn't it?
We are carrying out business over there. It's a
Yes.
for livelihood.
Right.
Now nobody will be going to that place. Now they are giving only 30 to 40% which has been offered of the plot area to 9 of us. And moreover, there is a toilet in the backside. Therefore, the place which has been offered
Is
to
the
us,
front side still vacant?
front side has been kept by them,
Them means?
by the contemners.
That means the owner, contemptor is the owner.
He has given an undertaking and there was a direction by your lordship that he will demolish the construction, he will demolish the building and he will construct the building and he was the position by my lord by 15/8/2023. What they have done is we have given back our position.
No, that I can
They have put in,
recollect.
They have put in at least 20 to 25 stall holders.
New ones.
At the front side.
All right.
And they are earning from it.
Right.
And they have offered us the backside portion of the said plot.
All
I
right.
remember the position is so precarious that no one is going to go over there and there is a bathroom in the said
And
backside.
you say the front portion is still vacant?
No.
And 9 can be accommodated?
The front portion is not vacant, front portion is under their occupation.
Their occupation means, is somebody occupying or is it vacant?
Through their main and agents.
That means it's occupied. Now there is no other place apart from the backside, isn't it?
That's one side of the picture. The other side is other direction by your lordship was to upon the learned advocate for the municipality.
Yeah, the corporation is there.
We have
what if your
18th March, Millard, the executive engineer placed the Millard plan before the meeting of board of
Board.
council. It has been approved. Millard, the owner may collect it from the corporation.
And we have been told that on Monday they will hand over the plan, but all my finances are ready. I'm ready to start construction from this month, my lord. My instruction is that by mid of August, I will be ready, my lord, to hand over the premises to the petitioners, my lord.
Show the plan to them. Are there places earmarked or not?
I will
Again,
show-
same problem will arise.
show them,
Front
my lord.
and back.
The moment I
middle.
get on Monday, my lord, I will show to them, my lord. No issue problem.
May I humbly submit to your lordship? Lordship, let it be determined after 2 weeks or as a lordship to direct. In the meantime, lordship kindly directs them to hand over a plan to us. And in the meantime, let them offer us some positions so that we can
Tell them which portion to offer.
But let them come and sit with us, man, because my instruction is that.
They are offering the back portion.
But my instruction is otherwise, my lord.
I have understood your problem, but then if somebody has already been placed over there, it will not be proper to displace them for 6 months. He says that by August he'll be able to deliver.
Kindly records that because
No, he'll come up with a document and the only oral instruction, do not rely. Let the client come. Why will the advocate be put in trouble?
No, no, I'm not on that. My lord.
Yes, let the client come, their undertaking is already there. They are in contempt. That is very sure. But then, only to keep things going, let us wait. Please come.
But my instruction is otherwise, my lord. My instruction is that we have offered them the best places, my lord, and no place is kept for me, my lord. Even my wife.
Through your men and agents. Best place at the back,
no,
behind the washroom.
No. I have photographs, my lord, which
Lordship, I have the photographs. If your lordship so kind enough to seize it for once, lordship.
My the photographs, my lord, can be, my lord.
The back portion to her where the bathroom is there. Lordship kindly see 70% has been taken by them.
But my instruction is otherwise.
Nothing can be understood from this photograph. Oh, what can be understood from here?
The frontal portion has been taken by them. That's the whole difficulty.
এটা থেকে আপনি কি বুঝবেন বলুন তো দেখি?
But I have photographs which speaks otherwise, my lord.
Get better photographs.
No, lordship, if your lordship kindly sees this one, my lord.
Yes.
If I may assist, this portion which is under the tarpaulin, under them, is the frontal side. Lordship kindly sees only this much has been kept for us. Only this much.
ঠিক আছে, দেখুন তো, learned advocate appearing for the petitioners submits that the contemner has offered the petitioners temporary shed at the backside of the subject place, just by the side of the washroom. Stop. The said place is unfit for carrying on business. Learned advocate representing the contemner submits upon instruction that apart from the place that has been offered to the petitioners, there is no further place left to offer. Stop paragraph.
Very good.
Learned advocate representing the Asansol Municipal Corporation submits upon instruction that the plan proposal filed by the contemner has been sanctioned and it is open for the contemner to collect the same from the office of the corporation. Stop paragraph. The contemner is directed to collect the sanctioned plan from the corporation and provide a copy of the same to the petitioners. Stop. The petitioners shall inspect the plan proposal to find out the place that has been earmarked for them. Stop. The learned advocate for the contemner submits that the construction work will start from the current month and it is expected that possession will be given to the petitioners by August 2025. Paragraph. The contemner is directed to file an affidavit disclosing his stand. Stop. The matter is made returnable on 24th of April 2025 for recording further updates.
My lord, my learned friend will hand over a copy of the plan to us.
He says yes. Why rope in your learned friend? Your clients are over there. Get it through them.
My presence will not be further required.
No, you stay. Why? You will not be left now.
Grateful to your lordship.
I am for the petitioner.
Yes.
As per your lordship's direction, I have sought, my lord. They have received it, my lord. This is the affidavit of service, my lord.
Who is the contemner?
Contemner is the my lord, chairman on Municipality.
Mushidabad Municipality. Who represents the municipality? Mr. Shubroto Ghosh.
Last, my lord, last is when the order was passed, Subhashis Chatterjee was there. I have sought, my lord, here.
Is it regarding payment?
Yes, ma'am.
Ad hoc payment you have received?
Yes, ma'am.
How much is left?
Left entire, my lord, only for ad hoc my lord, from 2017, my lord. All my lord, pension, no pension was there.
None represents the contemptor despite service. Let contempt rule be issued, returnable on 8th May. Requisites to be put in at once. Requisites for service of the rule be put in at once. Yes.
442. 442 Lordship, I am led by learned advocate Mr. Soboshaji Mukherjee. Lordship, due to his ill health, he is unable to appear in the court, Lordship. I am paying for just a 1 week of accommodation, Lordship.
Ill health?
Ill health, Lordship, due to that heat stroke, he has fallen, he is feeling a bit under the weather. That's why he is
Actually, nothing remains in the contempt application. Last direction was to annex the photograph. I have annexed the photograph. There's old structure, tile structure, and the last occasion, his senior took time to file. As your lordship desire, I have no.
Hey, did you file your, is the exception prepared?
Exception is not filed, Lordship.
Then?
Exception is not filed. Kindly give us 1 week of accommodation.
They admitted the photograph, but exception.
The photograph.
ঠিক আছে, দেখুন তো, learned advocate for the petitioner seeks accommodation. Stop. Exception to the affidavit filed by the contemptors has not been filed till date. Stop. As last chance hearing of the contempt application stands adjourned till 15th of May. Stop. Exception may be filed by the petitioner prior to the adjourned date.
15 May, huh?
Demolition has been done on 20th March and 21 March.
Demolition done?
My lord, the client has not made because already done, and so
today, my lord, my client has not come, but my
no
lord,
material
on the last week
made.
Last week he
No
came
material thing
and
played.
already told me that
Demolition done.
Told him bye-bye.
your part has already. My lord, this was my instruction.
Very well, please come.
Told him bye-bye.
Learned advocate appearing on behalf of the contemptor submits upon instruction that the unauthorized structure has been demolished. Stop. Learned advocate for the petitioner submits that substantial portion of the unauthorized construction has been demolished. Stop. Next. In view of the
practicable, my lord.
Yes.
As far as practicable.
In view of the above
এটা বলে
submission,
যাওয়ার।
there is no requirement of proceeding with the contempt application any further. Stop. The same stands disposed of. Rule ছিল কি না? Rule ছিল না. Very well, disposed.
My lord, deeply
Grateful, grateful.
444, my lord, it is our application.
Yes.
চলবে তো।
চলবে না।
It's a waste of.
My lord, it's a simple matter. My lord has passed the order. My lord, that order we have challenged by review application. That order, my lord, that is by fraudulent or by.
Who is for the writ petitioner?
My lord, as per your lordship's direction, we have already served.
Upon whom?
And my lord, it is the.
Upon whom did you serve?
Yes. Subbosachi Bhattacharya, my lord. তুমি দিয়ে দাও না, সার্ভিস করেছো যে দিয়ে দাও। We have already, my lord, as per your lordship's direction, we have already served. And my
No, the advocate is Soboshachi Bhattacharya and you have somebody, Gopinath Chakraborty has received. Who is he?
Because he is the advocate on record, Nikki.
Is he the on record?
He is the concerned advocate of the particular writ petitioner, my lord. Therefore, my lord, we are suffering a lot. My lord, kindly hear, my lord.
1 minute. Where the writ petitioner?
He is the clerk. He will not turn up because it's a simple matter. They will accept it. They have accepted it.
Soboshachi Bhattacharya is the advocate on record. And it has been received by Gopinath Chakraborty.
Yes,
Who is he? Is he the clerk?
Yes, clerk. We can assure, my lord, that.
Are you aware? Soboshachi Bhattacharya?
In the writ petition, I have.
You appeared in the writ. I can see your name. So copy must have been given upon you.
No, your affidavit is not served.
Then
My lord, that when the earlier occasion, my lord, that the affidavit of service is there, we have served to all parties. And my lord, your lordship specially directed on the last occasion that they serve upon Subhasachi Bhattacharya. And then, my lord, taking initiative, we have served upon the clerk of it, and Subhasachi Bhattacharya told that well, my clerk will accept it. And my lord, this is the personal, my lord, we can write down it on affidavit, my lord, because we are coming and going every time.
check up, it has been served in the
Yes.
GP's office. The slip is there. It is there. Check up.
Yes. My lord, it is a very simple matter, my lord.
But I will not hear without the petitioner.
But my
Please
lord,
come.
that the
State he is also not having the copy.
my lord, that the your lordship can do, my lord, that the he is the state. My lord, that the simple question is, my lord, that the panchayat, my lord, that the pradhan, whatever your lordship has directed, that direction is to be followed. That is that we have nothing to no quarrel. But my lord, the order, only because of passing this order, my lord, how we are suffering, there is no construction at all. By thought practice, they have made at least that they have come before your lordship and they have made an application and they have got the order. Very simple order. That means that if there is any construction, then let it be demolished. And my lord, that there is no construction at all.
Then nothing will be demolished. Why are you worried?
Then my lord, that will let my lord that the particular particular my lord panchayat, my lord, only my lord that the will do as per your lordship's order. That means that there is nothing at all. Only my lord that the to representation what has to be considered, that is to be considered within a time bound order, within a time bound period. That has not followed it. Only that is to be complied.
I did not follow.
My lord, that the order was, that means that within certain period, the panchayat pradhan will do and comply with the representation.
Yes.
And of the writ petitioner.
Yes.
There is no harm, there is no quarrel. But my lord, they are not, means rather.
If the pradhan is not acting in terms with the court's direction, you file a contempt. Why a review?
No, my lord, the contempt will not serve the purpose. Purpose is, if my lord, that either my lord, that at least one order be passed, that within 4 weeks you do as per order, then contempt will come. Or my lord, you can do one, your lordship can do one thing. Only principle of the actus curiae neminem graviti means for the act of the court, no man shall be prejudiced. Your lordship will kindly see. That means that it's the order of the panchayat pradhan, as there is a case, therefore that we are not in a position to give you the means permission. Means we are asking for a permission.
Permission for what?
Permission for raising construction, because there is no construction. Fraudulently, the petitioner has come up before your lordship that some construction is going on by ours.
If you are aggrieved by any action of the pradhan, you file a fresh writ petition. How is a review maintainable?
My lord, review the maintainable is, that means your lordship has passed order, and that order is prejudicing me, actus curiae neminem graviti. For the act of the court, no man shall be prejudiced.
Please, make this submission somewhere else, not before
No,
this
my
bench.
lord.
Please come.
No, my lord. Your lordship.
The
My lord, kindly hear me or not.
I have heard you.
No, your lordship will hear me.
I have heard you.
45 years of practice when I have come, and my lord, I have come before. My lord, kindly hear me.
Petitioner seeks
My lord,
review
kindly hear me or not.
of the order dated
If your lordship will have that very
16th
supposition, then my
April
lord, that your
2024.
lordship is, I think that means
Stop.
You are
The
humiliating the
petitioner
seniors, my lord. It
is
is very wrongful, my lord. You
the
cannot understand the problem.
the petitioner is
Yes, the petitioner has already
the
got some
petitioner
order.
is
Kindly see
aggrieved
the
by
paragraph
the
E.
act of the
Petitioner
pradhan.
has got fraudulently some order. Then whether I have to
Allegedly.
file fresh writ petition.
Allegedly
My lord, that if the
taken
third application is filed, then my lord, your
in
lordship is to take conclusion
compliance
here
of
and
the
now
direction
by perjury.
passed by the court on 16th April
And that is on
2024.
wrong footing. They have got it.
Stop.
They have
Paragraph.
stated, that means that there is a construction.
The
Paragraph
court
eight,
has
kindly see.
heard the submission
No, my
made
lord, your lordship
by
is
the
doing
learned
justice,
advocate
but it means justice
representing
very.
the
Your lordship
review
is examining the
applicants
seniors like us.
and is
You kindly
convinced
see paragraph
that the
8.
review
They have made
application
the
will not
they
be
have made the
maintainable. Stop.
Then,
The
my lord,
review
they have made the
application
perjurious application.
accordingly fails
Under section
and is
342,
hereby
they have
dismissed.
made an application.
It
Your
will be
lordship is
open
not
for
hearing
the
us.
review applicant
The
to
problem is, my lord,
approach the
don't be
competent
oversmart.
forum in
Problem
accordance
is, my
with
lord, that
law,
your lordship
if
is
so
very
advised.
He's showing yourself very oversmart. That is the entire problem.
Yes, call the next matter, please.
No, your lordship will kindly. No, I will not allow anybody else.
Sir, there is a
your
review.
lordship, I will not tell you.
Please.
I will not allow anybody else to make submission. Kindly hear me. If there is wrong.
Call the next
then,
matter, please.
No, my lord. Nobody. I will not allow anybody. I will not allow anybody. What your lordship will do? Your lordship, kindly hear me. If there is any fraud practice upon your lordship, then your lordship will have to see, not to diminish it in this way, that they go to face.
Yes, item
No.
445.
No, 440, I'll not allow. I'll not allow, sir. I'll not allow. I will,
Sir,
no,
somebody-
no, my lord. Kindly see. Paragraph 8. No.
Somebody be, if you are aggrieved by the court's order, there is a
No.
appellate proverb. You go over
Whether
there.
your lordship is encouraging the fraudship.
You go before the
No.
appellate court.
Where is the law?
You are a very
Your-
senior member.
No.
Please go before
No,
the
your
appellate
lordship,
court.
that means that the Sarvapalli Radhakrishnan's case, my lord, that the both the honorable chief justice, my lord, there is the full bench judgment. There the honorable court has stated clearly, my lord. There only the court where the fraud practice is there. Your lordship kindly see.
Yes, Mr. Banerjee, what
No,
happened?
my lord, I'll not allow Mr. Banerjee. Mr. Banerjee is well known to me, and I think that Mr. Banerjee will also see, because he is also making the submission, and we are also here to make the submission. There is no.
Even
your
I am very well known
No,
to
no,
you.
my lord.
Please do not make this type
No,
of
my lord, your
submission.
lordship is well about me, and your lordship knows me very well since
Very
the dawn
well.
of your
Yes,
practice.
yes.
And where I were the minister of
Yes.
junior lawyer.
All right.
But my lord, then your
If you are aggrieved,
No,
sir,
my lord,
please go in
this is the
appeal.
fraud we have stated.
Very well.
No, my lord, kindly have a look, my lord. It is for the in the interest of the all the concern we are saying. That means the Sarvapalli Radhakrishnan's case, my lord, honorable the Supreme Court has already stated that if there is fraud practice upon the court, then the court will take stand. Then well, kindly see.